All right, everyone, please be seated.
May I have a quick moment to confer with the state?
Yes.
I will need to approach it.
All right, thank you.
Did you approach, Judge?
Yes. All right, just for this moment. So a moment, Brenda, I'm gonna make sure that I'm connected to you. Okay. Yeah, yes, it's there. All right, everyone, happy Tuesday. What? I get no response. Happy Tuesday. It's supposed to be exciting. You know, it's not Monday, it's a Tuesday. All right, so I have to ask everyone, please make sure you take off your shades and your hats. That's not allowed. Thank you. All right, welcome to the 187 District Court. I'm the judge of the 187 District Court. If you see my glasses sort of darken a little bit, it's because of the lights, and these are transition lenses. I need these for distance, but not to read anything up close. So you'll see me take them on and off constantly. And my doctor said, when you're ready to get, when you're tired of taking them on and off, we'll put the little line in there. So I'm being vain. I'm like, no, I will never be ready for that. So that's going to happen a lot. So I'm Stephanie Boyd, and I want to give both the state and the defense a chance to introduce themselves to you. You're here for a case. The name of that case is the State of Texas versus ROLAND HUERTA. Could I have parties introduce themselves, please, for the state?
Marcus Sanders.
Brittany Sparks.
Rick Ramos.
Efrain Torres Jr.
And if you could have your client introduce himself, please.
Roland HUERTA.
All right, does anyone here recognize any of those parties that have just been presented to you? Do you know them from anywhere or seen them? All right, and what is your juror number, please?
It's 16. I'm David Goldman. I'm an attorney. So
All right, thank you so
I
much.
don't know them personally.
All right, and do any of the jurors know each other? When I say know each other, other than just meeting downstairs? All right, usually we will have a school teacher who has a student on the jurors, as among the jurors. And one time we actually had the current wife and the ex-wife. So there's nobody. They were friends though. They were like, oh, it's fine. But then they were not sitting next to each other. One was over here and one was there. So you have some very expensive cards in your possession, and they have numbers on them. So whenever someone asks you a question, or if you hear something you think it applies to you, or you just want to respond, be sure to raise that card and they will call you by number, because as you can imagine, it's very difficult for everyone to remember names. So Let's practice that. Could everyone please raise your card? Awesome. Thank you very much. Now, the other thing, a very important party to this jury selection is the court reporter. Our court reporter is Brenna DeMoss. Brenna, could you wave your hand a little bit so people know where you are? Okay. So here's the thing. She has to take down everything that everyone says. So what does that mean? That means please speak up. Please, 2 people at a time, don't speak at the same time. Although I know Brenna can get everyone's voice down, I want to make everyone's job easy for them. The other thing is, if you're sitting in the jury box, when a question is asked and you want to respond to it, you can remain seated because Brenna will be able to hear you if you speak up. If you're on this first row and you want to answer a question, Brenna will be able to hear you if you speak up. Everybody who's not on row 1, 2, or this 3rd row, whenever you have to answer a question, you want to answer a question, remember, raise your card and please stand and speak loudly enough so that Brenna can hear. Let's make her have a great Thursday today by being able to hear everyone.
It's Tuesday.
Tuesday.
Oh, wow. See, that's me checking to make sure everybody's listening. So I'm glad everyone knows the day. All right, so let's talk about the reason we're here. We're here for a jury trial, right? And so people always say that the best jury system in the world is the United States. Everybody always says that. And I have been traveling throughout the country at continuing education courses to see how things are done in different countries, right? Some countries you don't have jury trials, it's 3 or 4 judges. Some you do have jury trials. But you know what the key to having a successful jury system in the United States? Jurors. So if we don't have jurors, we cannot have a jury trial. So the case that you're here on today is aggravated assault with a deadly weapon. I just want you to think about that a little bit. I'm not going to ask you any questions to begin with about that, but just to have that in your mind. I know a lot of times people wish they had been selected for cases on the civil side. It's like, give me a car accident, I'll deal with that. Give me something else. But we need jurors on the criminal side, we need jurors on the civil side, we need jurors on the juvenile side. And I can tell you, as a person who's been a defense attorney and a prosecutor and on a jury, I know that you have certain cases that you wish you could be on. And people will probably ask you how you feel about a specific case, and people will say, oh no, I can't sit on that type of case. It's not whether or not it will be difficult for you to sit on a case, because honestly, any case that you sit on, it's difficult. It's whether or not it's so difficult that it will damage your psyche. So I want to talk about how we got here. How we got here is through an instrument or a document called an indictment. An indictment in no way signifies that someone's guilty of anything. It's just an instrument that will let somebody know what they're charged with. How many people here think that if you're going to be on trial for a case, you need to know what you're charged with? See, I'm practicing you with the cards. All right. So that's what an indictment is. And let me give you an example of that. How many people here have had a traffic ticket before? Don't be shy. I think the statute of limitations have ran. So, all right. So when you get a traffic ticket, maybe it's for speeding, maybe they're saying you didn't wear your seatbelt. What they'll do is, when I was growing up, I only had one, but when I was growing up, they would give you a piece of paper. Now everything is electronically, they probably do it differently, but when they give you that piece of paper, by you accepting that piece of paper, it's not saying I'm accepting it because I did it. It's you, well, it's them giving you information saying, hey, I think you were speeding. This is how fast I think you were going. This is where you need to appear to address this issue. So that's all an indictment is. It doesn't signify guilt in any way, shape, or form. Does everyone understand that?
Yeah.
All right. Thank you, number 4. Is there anyone here who thinks just because a case has been indicted and someone is here, that means that they're guilty. Okay. Now, the next thing, in the United States, people who are accused of things have certain rights. One of them is, of course, the right to a jury trial if they want a jury trial. The other is you have the right to remain silent. How many people have heard of that? Okay. Surely I have some people who watched Kojak. That's my era. Kojak, Maddox, Hawaii Five-0, where they always reach your rights. All right, so what that means is two things. When someone's arrested, they don't have to give any information. When someone's has a jury trial, they don't have to testify if they don't want to testify. And what the right to remain silent means is that you can't hold it against them. Now, some people say, oh, well, I wonder what they would have said. You can wonder, but you can't hold it against them. Does everybody understand that? Is there anyone here who will hold it against Mr. HUERTA if he decides not to testify? All right, that's number 45. All right, the other thing is everyone who is charged with a crime has a presumption of innocence. Has everyone heard of the phrase innocent until proven guilty? So what that means is the state has the burden of proof. And they have the burden to prove that someone committed an offense. And for criminal cases, that burden is proof beyond a reasonable doubt. Now, I know what your next question is. What does that mean? When I was in law school and I graduated, we had to memorize that definition. I knew it backwards and forwards. I could say it in my sleep. And after my first jury trial, guess what? They did away with the definition of proof beyond a reasonable doubt. So there is no definition for proof beyond a reasonable doubt. How defense attorneys, and how I would explain it to jurors as a defense attorney and as a prosecutor, is I would tell them what it's not. On the civil side, you have different burdens of proof. For example, if someone were trying to take away your rights to parent your child, terminate your rights, then they would have to prove that you were unfit by clear and convincing evidence. Clear and convincing evidence is a lower burden than proof beyond a reasonable doubt. So the highest burden is proof beyond a reasonable doubt. And that's the state's burden, and that burden never shifts to the defense. So what does that mean? That means that the defense doesn't have to prove anything. Does everybody understand that? Is there anyone here who says, well, I think the defense should have to prove something. If they don't prove anything, I have a problem with that. Is there anyone who feels that way? All right, number 11, 24, 31, 33, 34, 36, 41, and 64.
It's 57 as well.
And 57, thank you. Now, there are two phases to a jury trial, right? The first phase of a jury trial is where you determine if someone is guilty or not guilty. A lot of people believe that you're determining whether someone's innocent or not innocent, but you're not. What you're determining is whether someone is guilty. You're asking yourself the question whether or not the state has proven their case beyond a reasonable doubt. That's the first phase. If you do determine that someone is guilty, then there's a second phase in Texas, and that's called the punishment phase. And in the punishment phase, you make a determination of what the punishment should be. In this case, the range of punishment is anywhere, potentially, from probation, anywhere from 2 to 20 years in prison. Does everyone understand that? Now I want you to think about the range of punishment. Now, here's the thing about the range of punishment. You don't know anything about this case. When the state and the defense talk to you, they're going to be talking to you in hypotheticals because they're not allowed to talk to you about this case. You will only learn about this case if you're on the jury. So when I say the range of punishment potentially could be probation and anywhere from 2 to 20 years in prison, I'm not asking you whether or not you will give probation in a case where someone's charged with aggravated assault with a deadly weapon, whether you will give 2 years, whether you will give up to 20 years. It's that the law says that is the range of punishment, and you must look at everything and consider that range of punishment when giving punishment, if it gets to that point. Does everyone understand? And can everyone here consider the full range of punishment? Is there anyone who cannot consider the full range of punishment? All right, that's 6, 12, 31, 41, and 50. All right, the other thing I'm going to talk to you about is language, the English language. I think it's great when people can speak more than one language. When I was growing up, I took French. I'm originally from Louisiana, so of course I took French. And I took it in high school, I took it in middle school, I took it in college, and I tend to lose it unless I'm around people who speak French. But then once I'm around people who speak French, it comes back to me. But for some people, English is not their first language. So is there anyone here whose English is not your first language and you may have trouble understanding what's going on? Okay, number 53. Number 41 and 73. And number 10. I ask all these questions because, believe it or not, this has always come up. Now, the other thing, I want to know if anyone has any time constraints. Now, what do I mean by time constraints? I mean that you have airline tickets to go somewhere. You cannot cancel those. They're non-refundable. I can't use them. That's what I mean, that was a joke, people. So is there anyone who has any type of time constraints? All right, that's 44 and the, yes, 37. Okay, and number 18. Yes.
What time span are you considering when you say time constraints?
I'll get back to you, okay? All right, and number 31. All right, thank you. So I anticipate, of course, things happen in jury trials. You never know what's going to happen, but this trial potentially may be completed by Friday. That's what I mean by time constraints. Thank you. All right, so before I turn it over to the state and the defense, I'm going to tell you a story that is a true story. When you graduate from law school, people, of course, go into different fields. I always wanted to practice criminal law, so that's the field I went into. And in criminal law, we have a lot of jury trials. But usually when you're working at civil firms, sometimes you don't have a lot of trials, but you do have a lot of billable hours. So my friend Laura and I were extremely close in law school, and we're still close even though now she's in Austin. So when she was in San Antonio, she's like, Stephanie, I got jury duty. It's so fabulous. Maybe we can do lunch. And I'm like, oh, that'd be great. So she comes to jury duty. They do the first has, they take a break for them to have lunch. And I said, how's it going? She's like, oh, it's going fabulous. And I'm like, what do you mean it's going fabulous? Although I know you guys are having a great time here, but I was like, what do you mean it's going fabulous? And she's like, oh, I'm not going to get selected. And I said, what do you mean? How do you know you're not going to get selected? And she's like, it's like law school. I'm sitting in the back, you know, dodging questions, not raising my hand for anything. And I started laughing at her. And she's like, what's so funny? I said, you are so getting selected. And she's like, why is that? I said, I don't know why. And this has happened as a defense attorney and prosecutor. People who say nothing are people who end up selected on the jury. So the only way that you can tell the state and the defense that you desperately want to be on this jury, other than by not saying anything at all, is raising your hand and saying, pick me. Because it means the same thing. But again, we do need jurors in order to have a jury trial. And I really appreciate all of you for coming down today. So with that being said, I'm going to turn it over to the state.
Thank you, Judge. Can I turn on the?
Yes.
I'm so sorry.
Good morning, everybody. My name is Marcus Sanders. This is Brittany Smart. We're assistant criminal district attorneys here in Bexar. This part of the trial is called for dire. Some people call it for deer, and some people just call it jury selection. It's basically our opportunity to talk to everyone, see if you would be good jurors for this particular case. So the question is, can you be fair and unbiased in this case? Now, you don't know anything about the case yet, except that it's an aggravated assault. And so the question that I'm asking, or I'm going to ask, is sort of to flesh out, without directly telling you what the case is about, if we think it would be fair and impartial in this case. Not trying to embarrass anyone or pry into your business, but it's a question that we need to answer. If at any time I ask something that's too personal, you can let me know, and we can talk about it outside of the presence of everyone, just in front of the court reporter and the judge. So, question for you: why would someone be unable to be fair and unbiased? Can anyone give me an example? You're number 45.
Speak up.
Yes, sir.
By experience.
And what? Repeat the last part.
Take it personally because to some extent.
Anyone else can think of anything? You're number 34.
By knowing the person who's on the trial.
You know someone? For me personally, my first year working here, about 7 years ago, my car was broken into. I mean, at that time, I was doing misdemeanor cases, and so we had a lot of thefts and burglaries. And I always thought, like, whenever we had one, I was like, could this be the person who broke in the car? And I knew that if I ever got caught for guilty, I wouldn't be able to be very impartial because I would think that could be the person. Can you follow the law for this offense, for this case? If you're selected for the jury, the judge will give the jury charge at the end. It'll have all the law. As I'm going through this jury selection, I'll go over some of the law and some of the definitions for certain words. Can anyone give me an example of why someone would be unable to follow the law? You're number 19.
I don't understand.
Don't understand it? Okay. And if someone doesn't understand the law, then that's on us. We should make sure that everyone understands it. Anyone else? You're number 72.
I don't believe that it should be a law, maybe?
Yeah. That's usually the most common reason, is that they don't agree with the law. So consider possession of marijuana. It's sort of in flux right now in Texas. Does anyone have that? You're number 6?
Oh, no, I know
Who is it?
that.
Okay. What about that person?
William, yes.
That person? And anyone know who they are? Yeah, yeah. And so do y'all, you're number 26. Do y'all think that they would be able to be fair and impartial in a possession of marijuana case?
No.
Probably not, right? And so if you're selected on this jury, you'll have to take an oath that you can render a verdict based on the facts and the evidence that's presented. So as the judge said, this is an aggravated assault case. What is an assault? Anyone here know what an assault is? You're number 35.
Like battery, like you're beating up on somebody.
Anyone else? Jury number 8.
Infliction of bodily harm.
Infliction of bodily harm. Jury number 26.
Infliction of not just bodily harm, but mental harm as well.
Mental harm.
So it's both emotionally and physically.
Emotionally.
Emotionally and physically.
Jury number 36.
It's all of those, but it's also with the consent of the actual person who's being touched.
without the consent of the person convicted. So there's a legal definition according to the penal code. A person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse, or if the person intentionally or knowingly threatens another with imminent bodily injury, including the person's spouse, or intentionally or knowingly causes physical contact with another when the person knows or should reasonably believe that other will regard the contact as offensive or provocative. So the last one, 3, is a Class C misdemeanor. That's not something that we have here, so I'm going to be focusing on the first two. Intentionally or knowingly causing bodily injury or threatening imminent bodily injury. What is bodily injury? Can anyone give me an example of an injury? Juror number 29.
Cut.
Okay. Juror number 21.
Bruises.
Bruises.
Being shot.
Being shot. 14. Number 12. Broken bones. 22.
Scratches.
Scratches. Those are all great examples. So the code says that bodily injury means physical pain, illness, or any impairment of physical condition. So it does not require a visible injury. A victim can testify to pain suffering. Would everyone agree with me that there aren't always visible injuries, but there could be pain? Does anyone disagree with that statement? So, oh, sir, 64. Do you have, you want to expound upon?
I disagree with that. But there's always other ways to cause bodily harm. It doesn't always have to be physical evidence.
Okay, so you agree that someone can have pain or bodily injury without actually visible injuries. So this is a question I'm going to go around and ask every one of you to answer. The question is, if there isn't a visible injury from the assault, do you feel that criminal charges should not be brought? And so I'm going to ask you what your number is, starting with your number 1. 1, if you strongly disagree with that statement. 2, slightly disagree. 3, slightly agree. Or 4, strongly agree. So your number 1. Sorry, give me 1 second. Does anyone have any questions about what I'm? Yes. So if there isn't a visible injury from the assault, do you think that criminal charges should not be brought? So there should be a case if there is no visible injuries.
Excuse me, I'm sorry, just a moment. Can I have parties approach, please?
Switch it up just a little bit. So first, I'm going to go with the people who strongly disagree with that. The people who are in that first group, number 1. If you strongly disagree that criminal charges should not be brought, so since you feel like criminal charges should be brought, I want you to raise your hand if you strongly disagree with criminal charges should not be brought. Okay, yeah, I know.
It's the double negative.
Yeah. Let's put it this way. If you think that criminal charges should not be brought when there is no physical injury, raise your hand. Let's just do that. Yeah, so no visible injury. You think criminal charges should not be brought. Number 11, number 12, number 6, number 32. Did you ever record it? Number 30? 30? 34, 35, 41, 42, and 70.
So you mean like, I'm sorry.
Yes, 32.
If you can't see an injury.
All right,
then-
please stand.
If you can't see an injury, you should automatically assume that they're innocent. Is that what you're-
Well, not that far, but you feel that charges should be brought.
Okay.
45,
Please define visible, is it with a picture or you want the hospital that this case?
I'm sorry, sir, with the mask, you're gonna have to speak up, it's really hard to understand.
Please define visible, like a broken bone, you cannot see with a picture, but if you go to the hospital and see the skin, you can see. Visible define.
okay, and so what I mean by visible injury is that basically only the person's testifying that they felt. So everyone else is okay with no visible injury. You still think a case should be brought if the person says that they felt pain as a result of it? Yes. Next one, way that someone can commit assault is they intentionally or knowingly threaten another with imminent bodily injury. So a threat can be communicated by words or by actions. Pointing a gun at someone, pointing a knife at someone, running at someone with a knife, shooting at someone with a gun. So my next question, I might switch it up on the fly. If the assault consists of threats only and there is no actual injury, so this time there's no contact, there's no punch, being thrown or anything like that. Someone just threatens injury, for example, with a gun or with a knife, then who feels that criminal charges should not be brought? So it's just a threat. Yes, ma'am.
Can I ask you a question? Is it verbal then? Is it what you're saying?
It could be verbal or it could be me pointing a gun at you. So that would be an assault.
A question for you, well, sir.
36.
As far as threat, what if someone's going up to you and you're just telling them, hey, I know how to fight. You need to stay away from me or I'm gonna do anything. Is that considered a threat?
If someone just walk, like if I were to just walk up to you and say,
Well, I mean, if you're like a ball occupation and someone are talking to each other and they're, having a disagreement and the gentleman's like, you need to stay away from me. For instance, my brother's a special defense marine. He's required to tell people that he's trained in martial arts and in combat. Would that be considered as a threat to someone who is not? I mean, in some direction as far as like, if I were to tell you, hey, what if you put your hands on me, I'm gonna put you on the floor. Is that considered a threat?
that would be, and so following your example, that's a threat. So any type of threat of physical harm to another. Your number 6, I feel like that should be an offense. Okay. Anyone else? Your number 18. Anyone? Your number 38. So everyone else is okay with threats of physical imminent bodily injury. It has to be imminent. You're okay with that being an offense. So what makes an assault aggravated? Anyone have any idea? Your number 19, a weapon. Your number 20, a knife. Anyone else? Remember, an automobile. Okay, those are all good examples. Anyone else? 26.
Anger or angry?
Anger. Okay, and we'll sort of come back to that. Your number 33.
It could be an acid. It could be an acid.
Asset.
Yeah.
Your number 9.
Push.
Say that again.
How about push?
Pushing. Okay, we'll come back to that too. Your number 59.
It's something that's intentionally done.
Intentionally done. So there's actually 2 ways that someone could commit an aggravated assault. I'll give you a hint for the first way. Would you, looking at that picture, would you think that someone suffered a serious injury? And so under the code, someone can commit an aggravated assault if they assault someone and it results in a serious bodily injury. So if I were to push you, you fell, hit your head, fractured your skull, that would be an aggravated assault. If I just push you and there's no serious bodily injury, then that's a regular assault. So serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, a serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Does that make sense to everyone? Does anyone have any questions on that? The second way that someone can commit an aggravated assault, and a lot of you all hit on this one, is by using a deadly weapon. And so there's a legal definition for deadly weapon. A deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. So going back to that slide, would everyone agree that a gun is a deadly weapon? Would everyone agree that a knife is a deadly weapon? Does anyone think a knife isn't a deadly weapon? What about juror number 4?
It depends on the knife. I have a Swiss Army knife, so I would not want to fight with.
Okay, but is it capable of causing serious bodily injury because you use it correctly or wrongly? A sword? And what about a bat? I don't have a picture, but what about a hammer? Does anyone think that that's deadly weapon? Can be? Does anyone think like a hammer could be a deadly weapon? Juror number 34?
Anything that could be a deadly weapon?
Yeah, could it be a deadly weapon?
Pillow?
Pretty much. Yeah, pretty much anything can be a deadly weapon if the person's using it in that manner. So this is a legal definition of aggravated assault. A person commits an offense if a person commits assault as defined in section 2201. And that's what we went over again in the definition of a simple assault. And they cause serious bodily injury to another, or they use or exhibit a deadly weapon during the commission of the assault. And that's what we just covered the 2 ways. So use or exhibit. I want to go over that. Yes, of course.
Would it matter if we were involved in an assault, if we were assaulted at one point or another?
Like in your personal life?
Yes.
Yes, sir. And I'll come back to that towards the end. If someone were to shoot a gun at someone, did they use or exhibit it? If someone pointed a gun at someone, are they using or exhibiting? What about if we hold up a knife? Is that using or exhibiting a deadly weapon? Anyone have any questions on that? Use or exhibit, 34.
33 just said it.
33.
If you're exhibiting the knife, it's more of an exhibit than an use. For me, 34 personally would be the moment you actually thrusted the knife at somebody.
Okay. Does anyone agree with your number 34 that you have to actually make a movement? Your number 12? To use or exhibit. Or exhibit, because it's used or exhibit. And wait, I just 36.
As far as exhibiting, I mean, I think it has to come with the circumstances of what you're at. I mean, if it's like altercated at a chef's place, I mean, he's bound to have a knife in his hand.
Yeah.
I mean, he might just have it in his hand and not know to put it down.
Correct. And so I'm asking in the context of committing an aggravated assault. So I just have a knife on my person. I'm not committing an aggravated assault. But if I hold up a knife and I either say something towards you like I'm going to cut you, or I'm coming towards you and you can tell that I plan to use it. That's what I mean by use or exhibit. You're number 9.
Define.
I cannot. And that brings up a good point. So a lot of words in the code and the statute that we have legal definitions. If there is no legal definition, it won't be provided to you, and so you just use the common meaning that's prescribed to you. And so there is no legal definition for exhibit, and so if you were to ask that, if you were on the jury, we wouldn't be able to give you an answer. It would just be use the common use together. And so whatever exhibit needs to do. Striking someone with a bat, is that using or exhibiting? If you make it on the jury, you'll hear us talk about elements of the offense. Elements is just how we break down the law. For us, it makes sure that we hit everything that we need to hit in order to prove the offense happened. And so the elements of an assault is on or about a certain date, we have to prove that. In Bexar County, Texas, we have to prove that the defendant intentionally, knowingly, or recklessly caused the bodily injury to another. And we have to prove how they caused the injury. So we can't just say Brittany was injured, or we can't say Brittany was injured by me. We have to say how I did it and prove that I did it that way. So by punching, striking, kicking. So intentionally, knowingly, or recklessly. Those words have a legal definition that will be provided to you. It's the mental state. It's something that we have to prove. It's the difference between Class B, Class A, and felony offenses in Class C. Like Class C, like speeding, we don't have to prove that you intentionally knowingly did it. It's just if you did it or not. They all have a legal definition. They're long. I won't read them to you. They'll be provided to you if you make it on the jury. But here's a clip note version. So intentionally, it is your objective to engage in the conduct or the result. An example is if I have my phone and I say juror number 18, I don't like the way you're looking at me, and I throw it at her. Did I intentionally do that?
Yes.
Knowingly, you are aware of your conduct or understand that the consequences of your actions are likely to cause the result. I don't want to think of very don't think I juror number 7. Let's say I don't say anything, but I just pick up my phone and look directly at you. Is that knowingly? And it could be intentionally, but it's at least knowingly. Lastly, recklessly, conscious disregard of harm that might be caused by your actions. And so, good example for this one, all of y'all are pretty packed in there. I can see that you're pretty packed in there. I throw my phone out there. It's a good chance I'm going to hit someone, right? And so that's a conscious disregard. I know that it's likely to happen. I don't know for sure. May not be intentionally doing it, but I know that there's a risk that happens, and I still do. 46.
Yes, sir, I have a question.
Yes,
Do all three have to be met?
No. So intentionally, there's levels, and so intentionally would be the highest way. Like, I guess we call it a lesser included sort of, where intentionally is usually the more difficult for us to prove. Knowingly is a little bit lower. It just requires that the person that they did it, and then reckless is the lowest level. And so if the law that you're given says intentionally or knowingly, then it can be either one. Or if it says intentionally, knowingly, or recklessly, either one. It doesn't have to be all three. So even if it's only recklessly, that's enough to prove in that element. Does that make sense? So how do we prove someone's mental state? The example I gave, statements. If I said juror number 18, I don't like you. Can you tell that I intentionally did it? By my statements. By actions. Juror number 7, if I look at him and I throw it at him, I didn't say anything, but my actions can tell you that I did it normally, correct? And then sometimes it's just the surrounding circumstances. In this situation, I obviously can see y'all are packed in, and I just throw my phone at them. You can look at everything and decide if it was intentionally going through a reckless. So the elements of aggravated assault, on or about a certain day in Bexar County, Texas, defendant commits an assault and causes serious bodily injury or uses or exhibits a death during the commission of the assault. So what we don't have to prove, anything that wasn't one of the elements listed. So if it's not on that list, we don't have to prove it. The most common question is, why did the defendant commit the offense? That's not something that we have to prove. Is everyone okay with us not having to prove why a defendant committed the offense? 44 and 45, you are not okay or you are okay? You're both okay with it. Okay. Because who knows why the defendant did it? The defendant, right? You're number 4.
Distinction of self-defense in this?
There could be, and I'll get into that because as a state, we sort of have to predict what we think may come up in trial and talk to you about it. And so I'll go over that in a little bit. 34.
I would need to know.
You would need to know.
There's circumstances in every situation that I think should be useful.
Juror number 29, you agree with me, so why?
Yes.
Juror number, okay. Oh. So let's go with who needs to know why the defendant committed you would require us to say to prove why the defendant committed the offense. If you feel that way, raise your phone. Number 9, 11, 12. No, and I'll come back to that too. 9, 11, 12, 17, 18, 24, 28, 29, 30, 31, 33, 34, 35, 36, 37, 38, 42, 47, 48, 50, 56, 60, 57, 69, 70, and 75. So all 22.
Doctor, I have a question.
Okay, let me get 7.
My question is then, would that more come into the punishment phase? Why?
That's a good question, and yes, it should. But as far as guilt innocence, we do not have to prove it. We don't even have to prove that punishment, but it's something that you should consider if we got to that point.
For clarification purposes on your question, are you asking that your team, the prosecutor, should have the responsibility to state why the defendant did it? That's the defendant's party's job to do that, not your job, and that's what I'm trying to figure out.
So the defense has no job at all. Defense can sit there, they can play on their phone, they can go to sleep. They have no job in the job. Our job is to prove that the offense happened and prove it can be beyond a reasonable doubt. And so what we have to prove are those elements that we've gone over. What we don't have to prove is why. And so my question to all of you is, if we prove all those elements to you, we prove everything that we have to hit legally, but we don't prove why, we hold that against us and not find it guilty. 22.
Continue question. When you say we, like who does?
The state.
So who, okay, the state. So who will eventually do that? Who's going to tell us why?
Excuse me, just one moment, and I'm gonna pause your time. All right, everyone, the state has the burden of proof in this case. What that means is that the defense does not have to prove anything. That's not their job. So remember how I was mentioning about a traffic ticket? When you get a traffic ticket, if you want to challenge that and go to trial, guess who would have to prove that you were speeding? You don't have to prove that you were not speeding. Someone has to prove that you were speeding. So in criminal cases, when an indictment is brought and someone wants a jury trial, the state has to prove their case beyond a reasonable doubt. What they have to prove is what the law requires of them. So whatever the charge is, if it's driving while intoxicated, if it's aggravated assault with a deadly weapon, if it's criminal trespass, whatever the elements are in the statute, that's what the state has to prove. So if the element of motive is not in the statute, then the state doesn't have to prove that. So in this offense of aggravated assault with a deadly weapon, the element of motive is not listed. So the state doesn't have to prove motive. Does everyone understand? Now, a lot of times people want to know, it's sort of like Mrs. Kravitz and Bewitched. You want to know why someone is doing something, right? You would like to know what somebody's motivation is. And it's okay to like to know what somebody's motivation is, but you can't. And the law says that an element of motive is not something that the state has to prove. So you can't say, well, state, you didn't prove the motive of motive element. So therefore, we're going to be not guilty. Does everyone understand that? Does everyone understand that motive is not an element? You're welcome.
Go ahead, 31st.
Yes, so she just made it clearer. So can I take one?
Yes. So now that the judge has done a much better job than I did explaining it.
Can I take my vote back?
Who still feels that we, the state, should have to prove why someone did it, the motive behind the offense? 34. 31.
I just have a question.
Yes, sir.
What about a situation, I don't know the facts of this case at all. What about a situation where someone's a total accident and somebody gets hurt? Nobody intended to do it, they didn't do anything
that situation, that's where one of the elements would come into play, whether it was intentionally or recklessly. If it's a total accident, I mean, it would be up to the jury to decide if that was reckless or if it was even below that. So back to the people who would need a motive, need to know why, and we would require that we prove it.
I just have a question about defending yourself, defending property. As an example, I've had my truck broken into twice in the past month, so I carry a little bit of, I won't say rage. I'd love to come up on someone with a baseball bat as they're committing the act. Yeah. Is that assault?
That's the risk for me, so.
A month ago, I didn't feel this way.
I cannot answer that.
Okay, fair enough.
So where was that? 31, 34, right? 36, 42, 11, and 12. Y'all still need us to prove why they did it, right? Anyone else on this? 38. Okay. So, burden of proof, the judge covered this, it's reasonable doubt. We have to prove anything 100%. We have to prove or remove all doubt. Have to prove this beyond all possible doubt or beyond a shadow of doubt. Like the judge said, there's no legal definition. It's beyond a reasonable doubt. It's whatever it means to you. It's used in every jurisdiction across the U.S., so it's not some super high burden. The main question, the most important word in there is a reasonable doubt. If you have a reasonable doubt about one of the elements, then we haven't proved our case. But as long as the reasonable doubt doesn't go to the elements, like you may have a doubt about why they did it. Let's say some evidence comes out as to why they did it, but you're like, no, I'm not really sure that's why they did it. That doesn't go to one of the elements, and so you can't hold that against us. The reasonable doubt only goes to the elements of the offense. Does that make sense to everyone? Anyone does not make sense to anyone. So, is there anyone who feels that they would need to be convinced beyond all doubt to find someone guilty?
So,
Yes, sorry. Is there anyone who feels that they need to be convinced beyond all doubt? So you can't have a doubt in your mind in order to find someone guilty. Number 1, number 8, number 10, 11, 12, 17, 18, 24, 26, 27. Okay, let me see if I can ask that.
Yeah.
And
It's a small down, excuse me, I have a question, sorry, is it
Yes.
a little small down?
You're gonna have to speak up.
I was just, never mind, disregard. Never mind, disregard.
so
I see there's 1 through 3 up there, can we just say 1 through 3, what we agree on? Because it's like, I'm kind of in the middle ground.
Okay.
It's like, I feel like I need to know more.
And so,
I don't know if I have a doubt right now.
yeah, and
Does that make
it's,
sense?
And everyone, please remember, when the state and the defense are speaking, they're not speaking about this specific case. You don't know any facts, you won't know any facts on this case until you're placed in the jury box. So these are all hypotheticals. Does everyone understand? Thank you.
Disregard.
let me give a sort of silly example, but let's say you came here, do any of you have pets? Let's say you go home, your house is trashed. There's toilet paper, someone knocked over his dumpster, toilet paper everywhere, food eaten out of the trash. You see your dog, he has a little bit of food still on his face. Now, is it possible that someone broke in, trashed your house, framed your dog by putting a piece of food on his face, and then left? Is it possible? It's possible, right? But is that reasonable? No. Okay. And so that's what I'm getting at. It has to be a reasonable doubt. Okay, I'll take it.
Excuse me just a moment. I'm sorry, could you wait outside? A deputy will let you know where you need to go. Miss, yes, that's okay. All right, continue.
So is there anyone who feels that they would need to be convinced beyond all doubt in order to find someone guilty of a criminal offense? 11, 1, 10, 12, 17, 18, 24, 31, 34, 38. 41, 45, 50, and 71. Did I miss one? So types of evidence that you can expect to see in a trial. If it's a victim case, aggravated assault is a victim case. You can expect to hear from the victim. The people who investigate crimes, police officers, you can expect to hear from them. And maybe any eyewitnesses. All of that is evidence. If someone takes a stand and they swear to tell the truth, that's considered evidence, and you can consider that. Sometimes there's videos, sometimes there's physical evidence, or maybe a gun, fingerprints, photos, getaway vehicle, something like that. All of that is evidence that you may see and can take into consideration. So this is an example. So there's something called the one witness rule. My question is, would you rather be robbed here or here? And one time I had a partner who I put that slide up and he was like, I don't want to be robbed anywhere. And I was like, yeah, no one wants to be robbed. But let's say you had to be. You get out of work late, or you leave court late. We won't leave court late, but let's say you were, and it's dark outside, we're walking down the alley, and someone robs you. Or would you rather be robbed at a Spurs game full of people, lots of witnesses? Spurs game, right? But who chooses where an offense happens? Is it the victim or the defendant? Yeah, the person committing the act, they're the ones who choose where it happens. And most likely they're going to choose somewhere where there's not a lot of people. So the law says that if we have a case and we present evidence from only one witness, that person takes a stand and they swear to tell the truth. And they prove all of those elements that I covered. If they prove everything to you beyond a reasonable doubt, so you have no doubt in your mind, not a situation where, I know sometimes people say eyewitness testimony, shaky or things like that. Like you believe that person and you believe them beyond a reasonable doubt. That's enough. And we don't have to bring pictures. We don't have to bring video. That person's testimony alone is enough. Because let's say you were to get robbed and you go down to the police station and say, hey, someone robbed me. I know exactly who it was. It was juror number 7. And the person's like, whoa, was there anyone else there when it happened? The officer's like, no. And they're like, well, I can't do anything. You're just one witness. Does anyone think that that is fair? And so that's why we have a flaw, because a lot of times there is only one witness. And as long as we prove our case beyond a reasonable doubt, prove all those elements, that's enough. So my question now is, if there is only one witness who were to testify, if they prove all the elements to you beyond a reasonable doubt, would you be able to find the defendant guilty? Is there anyone who would not be able to find the defendant guilty if they prove all the elements to you through one witness and you believe that witness beyond a reasonable doubt? Is there anyone who's saying I need to work with that one witness? Juror number 4. Is there anyone? Juror number 45. Juror number 20. Juror number 58. Juror number 1. 7. And 41. And 45. 37. Anyone else? So everyone else is okay with just one witness proving all the elements beyond a reasonable doubt. You can find a
Quick question, is that witness the victim?
Does that change the answer for you?
Yes.
So the witness could be anyone. It could be the victim. It could be an independent witness. So should I mark it down as even more than one witness?
No, not necessarily. I mean, my mind would go to, does this person have something to gain from this? So if it's a witness other than the victim, they probably have nothing to gain from it. I probably would more likely to believe them than somebody who's gaining something from it.
And so in your hypothetical, you don't believe that person beyond a reasonable doubt.
Not necessarily.
You do still believe the person?
I'm a pretty good judge of people, so I would have to hear and see it for myself.
Well, you would need more than one witness. I feel like I should just move on. Like every time I ask.
All right, everyone, when they say one witness, this is what it means. Everyone realizes that the state has certain elements they need to prove beyond a reasonable doubt. Does everybody understand that?
Yes.
So if the state were to call one witness, what that would mean is you would have to believe that witness. So all of the extra questions that you're asking, well, maybe their testimony is shaky, maybe that's this, maybe that's that. That's you judging the credibility of the witness. So if the state were to call one witness, you would have to believe their testimony. So then if you don't believe their testimony, then you're like, they haven't proved their case beyond a reasonable doubt because this one witness that was called, I don't believe them. So the hypothetical is the state calls one witness, you believe that witness, and that witness testifies to every element that the state is supposed to prove, and you believe that person. Then can you go forward with the guilty verdict from that one witness? So to begin with, you have to believe that person and you have to believe everything that they're testifying to that goes to the elements. If you don't believe that witness, or if you say, well, you know what, I really don't believe that witness, I would like to have more, then you don't believe the witness. Does everyone understand? So that's what the one witness rule is. The first thing, you have to believe the witness. Goes to credibility. You believe they're credible and their testimony proves every element that the state has to prove. And they prove that element beyond a reasonable doubt through that one witness. Does everyone understand the hypothetical? All right, thank you.
Okay, so now, again, like the judge has explained better than I did. Who feels that they would need more than one witness? Raise your card, even if you raised them before. 1, 10, 7, 11, 12, 20, 24, 28, 29, 34, 35, 37, 38, 41, 42, 43, and 58. And 45. Oh, question, 45.
One question. It's because this is the first time I'm asking. I mean, I don't reason out what is jewelry. Ask me a little math, well, I don't know anything. That's the problem. I'm confused about the whole process. So if you call a witness and there's a picture, there's nothing, the facts that you're trying to prove is through somebody else checking your points. The law says that you're proving your case. Is that what you're saying?
If you find that witness credible and you believe that what they say and that they prove all the elements beyond a reasonable doubt. So because we have the burden of proof, we have to think about any possible defenses that the defense may try to raise. The one that comes up most common in a aggravated assault case is self-defense. The code says that a person is justified in using force against another when that actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. So I'll use the chair as an example. I've never built a chair, but I imagine you start at the bottom and make the legs first. I could be wrong, so if I'm wrong, let me know and I'll start. But the way that I like to think about self-defense is the chair. That there's 4 parts to it. That it has to be reasonable, has to be immediately necessary, and the other person has to be using or attempting to use unlawful force. Reasonable, immediate, necessary, and unlawful against unlawful force. If you don't have all 4 of those things, you're not entitled. The defendant isn't entitled to self-defense. Have you, a close friend or family member, ever been charged with or convicted of assault or aggravated assault, any type of assault of office? Your number 22. Charge or so it's 17, 18, 24, 30, 34, 35, 49, 54, 38, 65, 66, 68, 9, and 13. 69? Yes, ma'am.
What if the the person got arrested but never got charged, and the charges were dropped.
Yeah, so if they were,
So that falls under arrest because they spent a few hours. Okay.
and so everyone who raised your card for that question, again, it's going back to that main question, can you be fair and unbiased? And so if we need to get into the specifics of the person and what happened, and, but my question is gonna be is, if it happened to you or if it happened to a friend or family member, is anything about that person's experience with being charged, arrested, or convicted of assault gonna affect your ability to be a juror in an aggravated assault case? Like my example with the burglary, one of my father's working too. Juror number 30, juror number 9, 9, 30, 18, 22, 24, 35, 37, 38, 41, 42, 29, 11. Does anyone here know someone who they feel has been treated unfairly by the criminal justice system? Number 4, 11, 16, 17, 18, 20, 22, 28, 38, 50, 65, 69, 69. And same question. We can get into specifics later, but because of that person who was treated unfairly by the criminal justice system, do you think that you would hold it either against us, the state, or defense, and be unable to be fair and impartial in this case if you were on the jury? So everyone who raised their card, raise your card again if you feel like it will affect your ability to say serve on the jury and be fair and impartial for either side. 37, 38, 28, 50, and 11. I guess my overall question is whether you've had a negative experience or positive experience with law enforcement. Can you be fair and impartial? Is anyone who's had such a horrible experience with law enforcement that if an officer were to testify, or even because we're prosecutors, that you would hold it against us, hold it against the witness, and not be able to be fair and impartial? Your number 50. Your number starts.
Oh, 36. So that has nothing to do with officers?
Say that again.
Is that officers included in that?
Yes. So anyone would be unable to be fair and impartial because of negative experience with law enforcement. In 50, you raise your card. 38. Anyone else? 1. 28. And 36. 11. Yes, sir.
I am law enforcement, so I'll be clearly biased.
Okay. So you would be unable to be fair and impartial.
Completely.
And what is your number?
6'4", man.
64?
Yes, ma'am.
All right, so everyone, please remember to stand. If you're not in this jury box or on this front row, because Brenna will not be able to hear, which means it won't go on the record, which means it didn't happen. And if everyone could raise your number before responding.
Is anyone uncomfortable sitting in judgment of another person because of religious, moral, or philosophical beliefs? And the reason I ask this question is because if you're chosen on the jury, you'll have to deliberate and decide if the person feels your innocence. And so if you have some sort of philosophical, religious, moral reason why you can't sit in judgment of another, you can raise your card. 6, 11, 12, 17, 28. 38, 41, 46, 20, 50, and 56. we're going to raise your card on that one. I guess my question is it a situation where you would be unable to reach a decision either way? Okay, 6. Everyone else raise your card, I guess. Can you raise them again? 6, you would be unable to reach a decision. Juror number 11, same. 12.
Not exactly the same.
So would you? Sorry. So because of that, I guess if you're not able to reach a decision either way, would you automatically make a decision for one side or the other?
It's just the whole process. Just,
But would you be able to?
prefer not to, but if I'm placed in this.
17. Would you be unable to make a decision either way?
I can't hear you now. Yes.
Who else had their card up? 41.
Yeah.
Sorry, can you stand up?
Yes, I would be.
28. Who else? 38. 46.
I wouldn't be able to serve.
Okay. 50
I wouldn't be able to either.
and 56. For the last thing that is important is punishment. So in Texas, the trial is split up into 2 parts. The judge will touch on this. The first phase is guilt innocence. That's where we have to prove the elements to you now without. If we prove the case to you, then it goes on to the second phase, and that's the punishment phase. That's where other things can come in. The defendant gets to choose whether he goes to the court or there's punishment. Serving the jury must be able to consider the following punishment. Aggravated assault is a second-degree felony. The range is 2 to 20 years in the Texas Department of Justice. You must be able to consider the possibility of parole. If the person is sentenced to 10 years or less, then parole, probation is an option. And so, Judge asked this earlier, but who here would be unable to consider that full range, including probation, just because it's an aggravated assault case, without knowing any of the facts? All you know that it's an aggravated assault, and you're saying I can't consider the full range. 11, 12, 1, 14, 37, 31, 49, and 56. And let's start with 1. What is your issue with the punishment? Is it that you can't consider the full range, or that you can't consider probation?
I think it's a range of both. So I think my ability to judge makes me uncomfortable thinking that someone can either be on probation or be punished for up to 20 years. That just the factor of those ranges to me, for aggravated assault just seems something that I don't necessarily agree with.
Okay, so you think that the person shouldn't get probation, or that they shouldn't be able to be sentenced to 20 years?
I guess this goes more towards the last question when we're talking about you're being comfortable on judgment. I think for me, I didn't raise my card for that question just because I didn't think that it all varies. But then when we're talking about a certain range, like 2 to 20 years, that's where, in my mind, red flags are popping up.
Okay.
In terms of my comfortableness to judge for the specific.
And so are you saying, and I don't want to put words in your mouth, but because of the possibility that the defendant may come to you for punishment, that would affect your ability to make a decision on guilt or innocence?
Yes.
Would you be unable to make a decision on guilt or innocence because of that?
For the severity, for the range, yes. That would make it difficult.
Who else had a card?
Mine's probation. If I found somebody guilty of second degree, I guess depending on the circumstances, probation is a little light for people.
Okay, but is there a possibility, without knowing any of the facts, that you could get some information for aggravated assault?
All right, and here's the thing, everyone. You don't have to give anything. The range of punishment is anywhere from probation or from 2 to 20 years in prison. You have to consider it. So you don't know any facts of this case. Does everyone understand that? So when you're thinking about range of punishment, we're not specifically talking about this case because you don't know anything about the case. That's just the range of punishment of the law. Does everyone understand?
You're number 45.
I'm sorry, this is embarrassing, but maybe I know where my law there, then if I'm wrong. Is this something that you juror decide or the judge decides?
The punishment?
Yeah.
It depends, the defendant can elect to go to either the judge or the jury for punishment. Was there anyone else? 37.
Bias in this case, my husband got killed, sledgehammered at it 50 times. They're very strong to get.
Is there anything else that you think that we should know? Just like your number 37, if there's something that I didn't ask that you think that we should know, or you think that will affect your ability to be very impartial? 69.
I have two family members that were assaulted, have been assaulted. So I might be a little biased that way.
Okay. 62.
I myself. was assaulted.
Anyone else? 66.
I'm saying for own law enforcement also.
49.
Yes, I'm sorry. But I had a firearm pulled on years ago. Probation thing, I have a little bit of issue with that. I understand.
35.
I myself and my daughter had a gun pulled on him, and my daughter's case is now somewhere in the system.
That's 26.
You asked this a question previously, and it was about we had a family member that was convicted. So I did, like, but it was like statute of limitations. It was like years ago. I just don't think I was a liar, but I'm not unbiased. So that's the only thing I wanted to add.
Okay.
Yeah, no, I was shooting victim in a double homicide a few years.
Oh, wow. Sorry. Would that affect your ability to steal and aggravated assault case? Anyone else? 31.
Been assaulted, break this thing in prison.
Anyone else? Anything that I missed or anything that you want us to know? Thank you, everyone.
All right, everyone, we're going to take a short break before we turn it over to defense counsel. So I'll give you all a break till 11:10. Just make sure you're lined up back outside. Please leave the cards on your seats. Oh, yes. Yes, you All right, so everyone, before I turn it on to defense, I just want to let everyone know, you may see people coming in and out of this door and that they're handing me paperwork. That paperwork and what is happening has absolutely nothing to do with this case. Even though this is a case set for jury trial, I still have another docket that's happening. So with that being said, I'm going to turn it over to the defense.
Thank you, Your Honor. May I proceed?
Yes.
All right, good morning, everybody. I know it's been kind of long for you already, and I know you've probably been here earlier. What time did you guys get here today to check in downstairs? 8:30ish, 9ish? Okay, so I know it's turning into a long morning for you guys. I'm gonna try not to bore you guys to death, but if I see you guys nodding off, I'll know what I'm doing, okay? The other thing I wanted to explain to you guys before I get into it right now, I don't want this half of the room or those in the back to feel like I'm ignoring you. What we're doing right now, and we're dire, I know it's called picking a jury, but we're really not picking you guys. We're unpicking you, right? So as Mr. Volkman can testify to, he knows, we're basically seeing who would be a good juror for this case and who wouldn't, right? So basically, if we find out, you, sir, that you're not good, you know, we'll strike you, or for whatever reason may be, you won't end up on the jury. So those of you that remain, 12 of you, in order from 1 to 75, will be the ones who end up on the jury. So that's why the judge mentioned, you know, if you don't talk, you end up on the jury. And you guys here in the front, you guys are in the hot seat, right? Because if for whatever reason you haven't been struck, number 1 through, you know, the first typically 45, you guys are in the hot seat. So I don't want you guys to feel like I'm ignoring you. It doesn't mean you're safe. We may get to you, okay? But it's not very likely, at least I don't think from what I've seen so far. So I'm going to try to get some of you to talk, see if I can get some of you to open up, since I haven't heard from a lot of you. But to start off, my name is Rick Ramos. This is my partner, Efren Torres. We've been partners now 7, 8 years. I can't remember now. It's been flying by. As you know, this is my client Roland, and we have some family members here that are with us, just in case you saw them come in. So we really appreciate you guys being here. This is an important process and a very important day for him. So with that, I want to talk about we're dire. It needs to speak the truth. Now, with the state, some of you opened up, and I know that can be very difficult. I know some of you shared some very important things that happened in your life and family members who passed, and I really appreciate that, because I know that for some of us, myself included, you may never guess, but I get extremely nervous when I'm talking to groups of people, right? I'm naturally an introvert. I can come out, I can speak, I can do what I need to do, but I know what some of you may be feeling when it comes time to share something. And you may feel like, oh, I don't want to get up in front of all of these strangers and tell them what's happened in my life. So for those of you who have shared, you know, whether yourself has been a victim or a family member or whatever the case may be, I know how difficult that is. So we really appreciate that. So I think that it's only fair that if you guys are sharing some of your most intimate details of your life with us, I, as the defense counsel, should do the same for you, just to show you we're all on the same page. So a fun way that I thought of to do that would be to share what I would consider the worst thing that's ever happened to me and the best thing that's ever happened to me, right? It's nothing crazy, but I'd say the worst thing that ever happened to me, at one point in my life, I was engaged. To be married, I guess I could put that on one side or the other. It could be technically the best thing, I guess, depending what you're considering. But for me, it was one of the worst things that happened. Loved her very much. We were on opposite sides of the law and what we worked in, and we always clashed heads, right? Before we started practicing law, it was okay, but afterwards, it just didn't work out. She works for the state, I work for the defense, and she couldn't understand why I did what I do. And while I could understand why she did what she does, we just agreed to disagree, parted ways. Best thing that ever happened to me in my life was joining the Marine Corps at a young age. I needed that in my life. I was not a troubled kid. You know, I grew up fine, played sports, but I needed that structure. And I got to do one of the most interesting jobs that you wouldn't think that Marines get to do. I actually got to work. I was enlisted. So for those of you in the military, do I have any military members here? Awesome. Well, prior service, excellent. Well, thank you guys for your service. I really do appreciate that. But as a young enlisted Marine, I actually got to work what was called a civil affairs group. And we get to go overseas into other countries. And I would specifically deal with those areas, their jurisdiction, their legal side of things. So like in Afghanistan, for example, and we go over there and we're trying to help them establish a democracy. one of the things we were trying to do is get them away from what they call shurits, right? Because over there, their justice is, if something happens in their village, the village elder gets to hear them out if he wants to, and decide, yeah, you did it, now go ahead and pay him a goat, or give him some chickens or something, it's fine that you killed his brother, doesn't matter, right? So they didn't really have an established form of any sort of legal system. So, you know, as the judge said, the United States has one of the best systems. I truly believe that because I've seen it with my own eyes. I've been involved with it in other countries, and it's amazing the system that works here and the way that it works. So I can't thank you guys enough for participating in this because it's extremely important what you guys are doing here. So let's talk a little bit about your rights, right? When I say your rights, I'm talking about what you guys are going to be doing here today and throughout the week once we start the trial. You're going to get to decide whether or not Mr. Huerta is guilty or innocent of what the state is accusing that he did, right? You'll get to decide whether you believe every witness who takes the stand. We've got to believe an intern back here who's sitting in this witness stand. But the witnesses are going to come before this court. They'll sit up here. Judge will swear them in, testify, and they're going to talk to you. They're going to tell you their version of events and what they believe happened. You get to decide whether you believe them or not. Just because they get up there and tell you something, if the juror tells you the sky is purple, doesn't mean you have to believe them. You get to be the judge of that witness's character and whether or not they're telling you the truth, right? And you get to have your own opinion. Myself, Mr. Torres, Roland, the state, the judge, nobody can tell you how to feel about any issue, right? That's the whole point of Ordire. That's the whole point of our system. You get to feel the way you want to feel. You get to believe what you want to believe, right? And nobody can change that. You can't get in trouble for feeling that way, okay? When there's 12 of you who are seated here, you'll get to pick a foreman, right? That will be discussed with you a little bit later. That foreman will essentially speak for all of you. So it's extremely important that when you get to the back there and you're deciding who's going to be your foreman, you pick wisely because they are going to be the ones who get to speak for you, okay? And you have the right to have all the important questions answered, right? Once you start getting into the facts of the case, and we're going to not talk about facts, but I will talk about what the indictment with you here shortly, meaning what it is that Roland is exactly charged with. All of your questions that you have the right to have those answered, and that's going to be the state's responsibility to do that for you. So I'm going to get into some hypothetical questions. They're common sense. I will tell you if I'm tricking you, okay? There's no wrong answers. You can't get in trouble for anything here that you say, but show of hands, show me your numbers. Who here would plead guilty to an offense they did not commit? Nobody, right? I mean, it's just common sense. You're not going to plead guilty if you didn't do something. Now, who here would ask for a jury trial? Who would say, hey, I need to have my day in court if I'm accused of a crime that I did not commit? Who would do that? I think mostly everybody in here, right? These are pretty common sense questions. And who here would want somebody to plead guilty just because you didn't want to sit on the jury? You got a lot of stuff going on this week and it's not the right time to do this. Common sense, right? Nobody wants that. So that's why we appreciate you being here, right? Because that's what we're doing. And who here thinks jury service is important? Right. Is there anybody who thinks jury service is not important? I should ask that question because I've got some crazy answers before. No? All right. We've got a good group here. So I'm tricking you now. This is a trick question, but I want to hear some of your answers. Who is on trial? Who thinks they can answer that question? All people out. All right. Yes, sir. Okay, somebody. So you would think that Roland is on trial today, right? Thank you, sir. Yes, ma'am.
I think both are on trial.
Both of them. I like that. I've never gotten that answer before. I like that. Okay. Yes, sir.
All right, who's speaking?
I'm gonna
Because I
ask you to
can't hear.
speak up, just so that she can take everything down. Yeah.
It would be the same because they're trying to prove that like actually. Some things that happened within the case or did not happen.
Very close. I like your answer. He said, for those of you who couldn't hear him, he thinks it's the state that's on trial because they're the ones who need to prove what's going on. Anybody have a different answer? No? Okay, like I told you, this is the trick question, right? It's the accusation that's on trial, right? It is the state of Texas versus Roland Huerta. Whatever they are accusing him of having done, that's what's on trial. right? Because that's what needs to be proven. So you pretty much hit the nail on the head. I think it's the first time I've ever had somebody get close, so great job with that. It's the strength of it, right? How true is it? Or do we still have things that need to be answered? And why is that? Because they've got to prove all of the elements of the alleged crime, all right? So with that being said, these are the elements in the indictment against Mr. Huerta. I cannot get into any of the facts outside of what's in this indictment, okay? So the best way that I can describe this to you is think of a chef. Who here cooks a lot? Anybody cooks a lot? Okay, I'm gonna pick on somebody here. I'm gonna go with juror 34. Can you stand up? If I give you a cake, right, to bake, right? I know I said cook, you might say, oh, I don't bake, right? But there's instructions, you gotta follow those instructions, right?
Yes.
I think it's common sense, we've got ingredients to make that cake, right? All right, you can sit down, so I'm not gonna pick on you that much. The way I think of it, because I don't cook a lot, is a ham and cheese sandwich, okay? So let's pick on juror number 13. What's in a ham and cheese sandwich? All right, what else? Bread, right? So bread, ham, cheese. The three things. So if I told you I'm accusing Roland of being a ham and cheese sandwich, so I'm going to prove to you that he is a piece of bread, he's a piece of ham, and he's a piece of cheese. What happens if I throw a beef patty in there? Right? What if I throw a number 4 in there? What does that mean? It's not a ham and cheese sandwich anymore, right? What if I take out number 3 and there's no cheese in it? What does that mean? It's not a ham and cheese sandwich, right? I'm not tricking you guys, right? So basically what I'm getting at here is this is what the state has accused it of, right? And there's certain things that we're not going to fight about, Bear County and all these things, but it'll be your job, whoever's here, to determine, did the state prove to me their ingredients, right? This is what they have brought forward and said, I can prove to you 1 through 8, right? What happens if one of those is not proven? Who can answer that for me? I'll call on juror number, well, I saw a hand raised up over there.
Because not all the elements were taken care of, so it's not a complete.
We don't have a ham and cheese sandwich. Exactly. So let's move on here. Now, how does the state do that? We've heard a little bit about.
I'm sorry, I'm gonna object to the slide. Hopefully, I don't believe it's intended.
Can we approach her?
Yes.
Yeah. Can I proceed, Your Honor?
Yes.
Thank you, Judge. So how does the state prove to you the ham and cheese sandwich, right? By proving every single one of those elements beyond a reasonable doubt. Now, as the judge explained to you, Mr. Sanders explained to you, there's no definition as to what beyond a reasonable doubt is. But I want to go into a little bit more detail as to what those other elements are for you so that you can get a gauge of how important this burden is. Yes, ma'am. Were you
I have a
raising-
question about
Yes.
the last slide.
Yes, ma'am.
All the information was already there. Was it what?
All right, so everyone, if you're not in the jury box, if you're not on this 3rd row, you need to stand so Brenna can hear.
Okay, so in the last slide, there was basically all the information that we didn't know, we didn't have to know that we already saw, or how does that happen?
So you don't know any of the facts, right? This is just
Okay.
what the state has accused him of doing.
Okay.
It may be a ham and cheese sandwich, so we don't know. I can't get into facts with you as far as what happened. This is just what the state has accused Mr. Huerta as we sit here right now. Doesn't mean that any of it's true or untrue, right? That's what the trial is gonna be, okay? I just wanted you to understand that there's elements that must be met in their indictment and that they have to prove all of those and that they must prove all of those elements beyond a reasonable doubt for you, okay? So Mr. Volkman, this is where I'm gonna pick on you just a little bit. You do some family law, right?
In the past.
In the past, okay, are you still practicing family law? Or no, not anymore, okay. Well, you've done some family law, so
Yeah, but
I want to talk to you a little bit about these, right? So I'm a very visual learner. I've got to see it, I've got to feel it, or I'm not going to learn it. If I'm reading it or someone's just lecturing it to me, I'm not going to do it. So the best way that I can do that for you is I want you to picture a football field or a line that starts here and goes all the way to the end over by the wall, okay? So we would start with the first burden over here, okay? And technically, there is one burden in the law. It's called a scintilla of evidence, right? It's not on there, but that's a very tiny burden. It's a little bit of evidence, right? Then we jump to reasonable suspicion. This, for example, is what an officer would need to pull you over, right? You're driving in the street, they see that you got a busted light or what have you. The officer just needs a reasonable suspicion that a crime has occurred, whatever it may be. It can be a violation of transportation code, penal code, anything. They can pull you over. Okay, doesn't mean they can arrest you yet. Why? Because once they stop you, they've got to investigate a little bit more, and we jump to the next burden of proof, right? At this point in time, the officer has to have probable cause to make the arrest. Okay, so they do their investigation while they're with you on the side of the road or what have you, or they do what they need to do. They build their probable cause. At that point in time, they can take you under arrest, right? So that's why we talk about when you're under arrest, it doesn't mean you're guilty, it just means that there's probable cause, right? The officer did a preliminary investigation, whatever that may be, decided he had enough, he arrested you, okay? So then we jump up to the middle. So I would be at the 50-yard line, just about right here, okay, if we were on a football field. And this is by preponderance of the evidence, okay? So if we were to go to court in a civil case, and let's say that I crashed into you, ma'am, and I rear-ended you, and you say, you know what, I'm gonna go sue you because now my back hurts. In order to take my money from me or from the insurance company, you would have to go to court and just prove by preponderance of the evidence, which means that the greater weight of the evidence, right? So the scales of justice, you tilt them over ever so slightly in your favor, you win, right? You met your burden, okay? Now, who here has kids? So I'm gonna pick on somebody here. Ma'am, I'll pick on you. How many kids do you got?
One biological and two step children.
One biological. How old are they?
My biological son, which is the youngest, is 28.
Okay. Well, they're not little anymore, so I won't feel too bad picking on you anymore. Okay. So, but let's say that your son was, under 18, a minor, and Mr. Volkman, this is where I'm going to pick on you. I'm not saying Mr. Volkman would ever do that, right? But when he was practicing family law, and if he decided, you know what, I think you're a bad mother, and I want to take your child away from you. It's a pretty big deal taking someone's kid away, right? I mean, it's not a little thing to take someone's child. But if Mr. Volkman decided that's what I'm going to do, he's going to file his lawsuit, he's going to take you next door into that civil courthouse. His burden, you believe, would have to be pretty high, right, to take someone's child away, right? That's what clear and convincing evidence is. If Mr. Volkman wanted to take your child, that's what he would have to do. It's a high burden, right? What's even worse than taking someone's child? Taking their liberty, right? Well, I mean, killing them, of course, right? But without killing them, taking their liberty in a judicial system, right? So that's when we get all the way to the end of the football. Not all the way, right? But, and I want to make sure that we're clear, beyond a reasonable doubt doesn't mean beyond all doubt, right? But beyond a reasonable doubt, right? If I were to ask you to believe that an alien came down in Mr. Sanders' example, and he's the one who came in and messed up the house and left the dog with food, I mean, we're not being reasonable, okay? But the last burden on all of the evidence burdens is beyond a reasonable doubt. Higher than taking someone's child. That's the best way that I can describe it. Anybody have any questions over it? So with that being said, I'm going to get into more general theories now. I want to talk a little bit about, I know I've got some law enforcement guys, so I'm going to pick on you a little bit, okay? I want to talk about police officer credibility, right? There's certain people, certain biases that I'm talking about. When I say bias, I don't want you to feel that that's a bad thing. Everybody has their own biases, right? If a Marine were to walk in here in his full dress blues and get on that stand, I don't care if he tells me that there's a tornado going on right now on top of this building when there's a perfect sunny sky outside. I'm gonna believe that Marine no matter what he says, why? Just because he's the nature of my bond with him, all right? Same way, I'm sure some of my law enforcement guys are gonna feel, as they talked about, you know, that they think they might have that bias because they are law enforcement officers, okay? So I want you to think about this question a little bit, right? I have a scale there from 0 and officers just like everyone else to me. 5 is they're more believable than others, and 10, the same example that I use with my Marine. If the officer says they did it, they absolutely did it, right? So think about where you fall on that scale from 0 to 10, right? No right or wrong answers. No one's gonna get after you. You're not in trouble. I just need to gauge to see how you feel if an officer were to take a stand. And the way that we're gonna do this is, as you think about this, I'm gonna start with 10, and I'm gonna ask you, do you feel they're 10? And I'm gonna work myself all the way back down to 0. When we get there, please just raise your hand up or with your number, and I will call you. Once I say your number, you can put it down, okay? So I'm gonna start with my 10s. Who feels that if the officer did it or says he did it, it's a done deal? He did it. Who's a 10? So I've got juror 46 and 64. Who's at a 9? Anybody at an 8? 7. At a 7, I have juror 57, 35, 31, and 23. Who's at a 6? I've got 58, 72, 75, 49, 54, 34, and 37. Who's at a 5? Okay, we got more people at a 5 here. I'm going to start over here. I've got juror 8, 9, 10, 13, 14, 19, 25, 26, 27, 29, 22, 30, 40, 41, 36, 43, 47, 56, 66, 71, 69, and 73. Am I going way too fast for you, or am I good? I'll slow down just a little bit. 9, yes, sir.
We got another 10.
I'll put you on a 10? All right, yes, sir. We've got number 9 at a 10.
Can I add a note to my code, depending if the race of the defendant,
I'm sorry, sir?
can I add a note to my code?
Yeah, let's put an asterisk. What's going on?
Depending on the race of the officer and the defendant.
Okay, depending on the race of the officer and the defendant, okay. Let's go with number 4 now. Who's at a 4? I've got juror 3, 11, 12, 20, 24, 28, 62, and 67. Who's at a 3? I've got juror 42, juror 2, and juror 70. Who's at a 2? I've got juror 4, juror 7, juror 18, and juror 63. Who's at a 1? 52. Yes, sir. You have a question?
Please, just
Yes.
clarification.
Yes, sir.
Might be obvious, but isn't a police officer part of the criminal justice system?
Well, it depends who you ask, right? If they're a good cop or bad cop. But yeah, we would like to believe that they are part of the system, right?
Follow-up question.
Yes, sir.
Police officer, just like anybody else, they're sworn in to tell the truth.
Absolutely. Yes, sir. And who's at a 0? Okay, I'll read these slowly for you. I've got juror 1, juror 6, 15, 16, 17, 21, 60, 59, 61, 65, 74, 33, 32, 38, 30, is that 39? Yeah, 39, 48, 50, 44, and 55. Yes, sir.
To a 0, I misunderstood it.
You want to change yours to 0? Okay, 43 is going to be a 0. Okay, so I'm not beating up on anybody. There's no wrong answers. 51, yes, sir. 0, thank you, sir. So there's no wrong answers, right? But there's a saying that we like to use in the defense community, right? It's a three-piece, right? Doesn't matter if the person's a preacher, a prostitute, or a police officer, right? Everybody who comes into this courtroom starts off in the exact same footing. That's the beauty of our system. You as the jurors will get to decide whether or not you believe that person, okay? I want to talk to you a little bit about Mr. Huerta now and his rights, right? Judge talked a little bit about his right not to testify, right? We as the defense, when we come before you today, we don't have the burden of doing anything. We don't have to say one word throughout the trial. If I wanted to sit here during the entire trial while Mr. Sanders presented his case and play Candy Crush on my phone, I can do that. I'm not saying that's what I'm gonna do, right? But that is our responsibility, to do nothing and hear what evidence they've got. And if you at the end of it feel, hey, that's enough, we felt they proved beyond a reasonable doubt that he's guilty, then so be it, right? As the defendant, he doesn't have to say anything, doesn't have to do anything, doesn't have to present one piece of evidence, okay? So what I'm trying to get to the bottom of here is your feelings when it comes to that, right? Because it's a natural feeling for people when they say, I've been accused of something and I'm saying I didn't do it. I should go and present, hey, this is why I didn't do it. And I shouldn't be afraid to testify, okay? But knowing what the law is now, right? Knowing that we don't have to do anything at all. I want to know that if he does not testify, he'll give you his version of events. I want to know if you would hold that against him. No right or wrong answers here. Again, we're going to do this in the same way. I want you to think about this. I'll get with you right now, sir. I know you got a question. And I want you to think from 0 to 10, right? 0 being, nope, won't hold it against him. I understand what the law is, doesn't have to say anything. Or 10, if he doesn't testify, means he's guilty, right? Because he's sitting there quiet. That's the extreme. I'm not saying you guys are 10, but I need to know because some people do feel that way and it's okay if you feel that way. But if you do, I need to know it. And before I get into polling, yes, sir, I know you had a question. And if you could stand up for the floor.
Yes, which is, before I was asking, in case the jurors decide the timing, I feel, you said, I want to trouble the same. That if I don't hear the reason why, that could really. You know what I'm saying?
So you're saying that you could be affected if you don't hear the why?
Pretty early on the.
Okay. Yeah, I think we kind of got into that with the state, right, in regards to what their burden would be. So I appreciate you telling us that, right? If you feel that way, again, you can't be in trouble. We just need to know it's how you feel. So I'm going to start off again with on the 10 side, right? Basically, you're telling me at a 10, I got to hear from him, Rick. If he doesn't get up there and tell me what happened, I'm going to believe that he's guilty. Okay, so who feels that they are a 10? And you were a fast one, so I appreciate you. I've got number 64. Who's at a 10? Number 64. Anybody? Okay, how about a 9? An 8. On 8, I've got 29 and 36. On 7, 6, I've got there's 20, 25, 48, and 56. Can we raise those one more time? I believe it was 20, 25, 48, and 56. 5, we're at some negative impact here. Okay, so over here, I've got juror 1, 10, 11, 12, 14, 18, 28, 24, 31, 33, 34, 35, 41, 40, 49, 46, 45, 58, 62, 65, 66, 69, 70, I think yours is backward, but you're 71, right? Okay, and 75. Okay, I'm gonna make this a little bit easier and smoother for us. Okay, I think that was 5, right? Or 4. I want to know who's 1 through 4. Basically not at a 0. 1 through 4. You want to go to 0?
I want to go to
About 4? Okay, 1 through 4. So I want to know 1 through 4. I've got 3, 4, 8, 15, 17, 19, 57, 63, 27, 25, 23, 22, 30, 37, 38, 39, 43, 68, 67, 50, 47, 52, 53, and 54. Okay, who's at a 0? Oh, okay, before I get into my zeros, I've got a question. Yes, ma'am.
I just wanted to clarify something.
Sure.
I understand that the law says that doesn't have to testify, right? I get it. I guess I chose a 5 not necessarily because I won't be able to differentiate that. It's just more on his own part, like I will feel like he should say something, but that doesn't mean I can't follow the law, though. Does that make sense what I'm saying?
I appreciate you. Can you hold that thought because I'm gonna get into that right after I get my zeros. Okay, we're gonna get into that here. I just want to know who's at my zeros right now. Okay, and then my 0, I've got 2, 6, 7, 13, 16, 21, 60, 59, 61, 26, 23. Change it, yes, you can. Yes, 23, 32, 42, 72, 74, 44, 51, and 55. Okay, so basically, everyone that's not at 0, you're all that numb, okay? But for those of you who are not at 0, just like 33 said, it was perfect, right? I need to know, right, if the judge says, look, guys, I get that you're not at a 0, but I need you to understand he has the absolute right, his constitutional right. The Constitution tells him he does not have to testify, and you cannot hold that against him. So off the top of my head, Mr. Salcedo, I know you're number 1, so I'm going to pick on you a little bit here, okay? If I, myself, and Mr. Sanders and the judge herself explains to you, hey, look, you got to put him at a 0, right? You can't hold it against him. You can't get in trouble. She's not going to arrest you. Bailiff's not going to run out here and arrest you, right? But if they told you that, would you still feel the same way? Like, look, it's just the way I feel it. I would hold it a little bit against him if you didn't. I couldn't completely ignore that. Is that how you feel?
That's a tough question to answer.
Okay. Let me put it to you in terms of this, right? Are you married or a girlfriend or anything? No? Okay, well, if you did, right? Let's say, like, I've got a girlfriend now. The best way I can explain this to you is, let's say I told her, hey, I'm going to Vegas for the weekend with the boys, right? And boys trip. And of course, the question comes, babe, are you going to behave? Are you going to cheat on me? Right? That question or my answer better be an absolute 0, right? Because if I tell her that's a tough question to answer, we're going to have some issues, right? It's not going to be good in the home anymore, right? So that's basically what I'm asking you here. It's like, are you going to cheat on me, essentially, right? When you go to Vegas, because you have to give him his constitutional right, that benefit, right? If I put it to you in terms of that way, how would you feel? Would you still feel like it's tough, or I couldn't be at a 0, or how would you feel? Again,
it's the possibility of being a 0.
A possibility. Okay. Is there anybody, after hearing my explanation, and I'm asking you, are you going to cheat on me when you go to Vegas, right? That would change their answer to a 0. Or I guess the best way I can put it, who would not change their answer anymore. Okay, you know what? I can't not hold it against him if he doesn't testify. Who feels that way? And please raise your numbers high in the sky for me. So I've got your 18, 25, 34, 35, 43, 49, 4, and 14. Anybody? 38.
And this is not hold it against him.
This is to hold it against him if he did not testify.
Hold it against
Yeah.
him.
Oh, okay, so who would hold it against him if he did not testify? Let's put it there. Change it to 0. Okay, so if he did not testify, Mr. Huerta did not get on the stand and tell you his version of events, you would hold it against him. I've got your 65, 35, 34, 36, 64, 14, 4, 41, 49, 29, 48, and 69. Thank you all. So that brings me to my next point now, the presumption of innocence. So the best way that I can describe this, right, is basically the burden is that the state has to prove he's guilty beyond a reasonable doubt, right? And we've all heard the term that you're innocent unless you're proven guilty, right? Everybody is innocent unless the state can prove them guilty, right? As Mr. Huerta sits here right now, he's innocent unless the state can prove otherwise during their trial, right? There's some people who can't, wrap their minds around that, right? And I know it's common sense, and some of you be like, what? It's ridiculous. I don't want you to feel that way because not all of us deal with this legal system on a daily basis, right? So some people feel like, hey, if you're sitting there, you've been arrested, and you had to have done something. You're at least a little bit guilty already, right? But the law says that he is innocent unless the state can prove him guilty. So the best way I can describe this to you is I'm a big sports fan, right? Love my Dallas Cowboys, love my Spurs. If you're another team fan, I'm so sorry. Please don't hold it against me, okay? I still hurt for my Cowboys and I'm hurting for my Spurs right now, but the way I can describe this to you, right? And I saw somebody in the back, I think you were wearing a Cowboy shirt, right? So Cowboys, hopefully this is our year, right? Like every year. But the way I can describe it to you, who here is like a diehard Spurs fan? All right, we're in San Antonio, so let's pick on someone who's a diehard Spurs fan or any team fan who has like a team that love them. Yes, sir. 49. Go Packers. Can you stand up? Oh, go Packers. Cheese says we got a cheese that is wearing his green today. I love it. Thank you, sir. So I'm going to pick on you a little bit, especially since you're a Packers fan. All right. What would I have to do to change you to come to the Cowboys team, to be a Cowboys fan?
Never happened.
Never happened. Right? That's a good answer. Thank you, sir. You
Although I did hear that they're moving the Super Bowl to some place where the home team will never have to play.
Yeah. It's going to be in Cowboy Stadium every year, right? Yeah, I appreciate that. So, like he said, right, it's extremely difficult to change someone's team. So the best way I can describe to you this whole process in the presumption of innocence is the 12 of you who sit in this jury, you are team innocent. Every single one of the 12 members who sit here will be team innocent. If I could have shirts made for you, I would, right? But as we walk into this courtroom, you are team innocent with Roland, right? We got to be diehard. Just like my friend here is a Packer fan, we got to be diehard, right? It's our constitutional right to the presumption of innocence. It's a huge deal, our Constitution, right? People died making sure that we have that right, right? Those of us in the military know how much we value that Constitution, right? And the rest of us as well, our law enforcement officers, we know they go out and they defend that Constitution each and every day, and they make sure that no one's rights are being violated, right? So the 12 of you here will be team innocent with us, right? It's the state's responsibility to get you to change your team. That's their job, to get you to change from team innocent to their team. High burden, tough thing to do because we've got to make sure that we're diehard team innocent, okay? So talking about that presumption of innocence, right? We've got our scales again. 0 being that, you know what, as Roland sits here right now, I see it, I'm team innocent. Constitution gives him the presumption of innocence. At a 0, he is completely innocent as he sits here right now. And 10, you're feeling that very likely he's guilty. Going through this process, we've got a panel of jurors here. I feel that he's guilty. And 5, you're in the middle, right? There's a good chance that he's guilty of what the state has accused him of. So I want you to think about that for a little bit. 0, completely innocent. I'm on board. I'm team innocent already. 10, the extreme side of things. And if you're there, that's fine, right? That you feel very likely that he is guilty or somewhere in between. So I'm going to break this up to make it easier so we're not going number by number, okay? What I want to know is everybody between a 6 and a 10. Who feels that as he sits here right now, it's above a good chance that he's guilty, all the way to very likely he's guilty, as of right now, without hearing any evidence whatsoever? We've got juror 46 and we've got juror 64. Thank you, guys. I want to know who's at a 5 in the middle right now. I've got juror 10, 9, 11, 28, 29, 35, 36, 38,
I didn't hear you.
28 said he wants to change his answer. 48, 49, 56, 62, 65, 66, 70, 71, 72, and 73. Now I want to know who's between a 1 and a 4. Who's on the lower end of that scale here. So I've got juror 1, 8, 7, 12, 14, 15, 17, 18, 19, 23, 24, 28, 34, 40, 41, 43, 47, 50, 58, 67, 68, and 75. And who are my zeros? Who's innocent right now? So I've got 2, 3, 4, 13, 16, 21, 22, 25, 26, 27, 30, 32, 33, 39, 42, 44, 51, 52, 53, 54, 55, 57, 59, 60, 61, 63, 69, and 74. So for those of you who are basically not at a 0, then I'm going to pick on juror number 10. Okay, where is my 10? Yuma, okay. I'm going to use the same example as I did with Mr. Salcedo here. If I were to tell you, look, I get how you feel, and I really appreciate you being honest with us, but I'm going to ask you if you're going to cheat on me now, okay, going to Vegas. The law says that you have to give him the presumption of innocence. I mean, that's even more important than his right to remain silent, right? The presumption of innocence. Is that something that you feel that you would be able to do, regardless, knowing the law, that you have to give him that presumption? Do you still feel that you would be not at a 0? You would feel you would not be a 0 right now. You would not be completely innocent as he sits right now. Is that correct? And can you just say yes, because she can't take down the, yes, okay, thank you. Not being rude to you, just so she can write it down. Is there anybody else who was not a 0? Who says, you know what, Rick, I understand the law. I get it. You can explain it to me. Mr. Sanders can explain it to me. Judge Boyd can explain it to me. It's just the way that I feel. I get that he has the presumption of innocence. I get that the Constitution says that, but the way that I feel, it's just being here, seeing what's going on. I feel that, you know what, he's a little bit guilty. I can't give him that benefit of the doubt. Who feels that way? If you can please raise your number. I've got juror 34, 64, 35, 49, 48, and 46. I've got 14. All right. And I appreciate you guys' honesty, right? This is how we decide. 29. Who could potentially be a good juror or not for this case, right? So we've already talked about the 5th Amendment. I want to bring it up just real quick again. Can anybody give me examples where somebody would not want to testify at trial? And I'm going to ask you to raise your number before you speak. I got you, sir. 8. Yes.
Somebody might not want to speak if they think that it might negatively if they were to get up and speak. They didn't come to explain why they were in this situation, but they didn't do it. But going up on the staff would make it worse for them.
Perfect answer, right? So for those of you who couldn't hear, juror 8 said that a person may not want to say something that may negatively affect them, right? Maybe they didn't do something, but something may come off wrong, so they don't want to get up there and basically hurt their case. Did I say that properly? Okay, so who's some more examples? I just gave one of you on that. Yes, juror 57.
If a person does not express himself well or in any type of language fears to be misunderstood when they do say something, they might remain silent as well.
Yes, good answer. So say they don't want to be misinterpreted. Somebody else, 59?
Yeah, some people do things like shake or wring their hands when they talk, or they might have stutter. which other people might take as a sign of guilt when it's really just there.
Not a good witness, right? Good one. So I had a juror 45 real quick. I know you had raised your card up earlier. Same answer as juror 8. Thank you, sir. 33.
Perhaps they don't even understand what the crime is about.
Good answer. Maybe they don't understand what's going on. Did I see somebody over here? 7. Yes, sir.
They feel that the state hasn't proved their case, so they don't need to see.
Right? They feel that the state hasn't proven their case, so why are they going to get up there and add anything to it? Right? Any other examples? Fear is one I'm giving us hints of here. 22.
What would happen in the case of a language barrier if the person doesn't speak English?
That's a great, if you're asking me what would actually happen in a courtroom and somebody wanted to testify, the court would have interpreters come for them and testify for them. But it could be another reason they don't want to, right? Something may be misinterpreted. Too much pressure, right, going on with their case. State hasn't proven its case, or the big one, right? Maybe they're guilty and they don't want to get up there. All of these are possibilities, but we can all agree that there's multiple reasons why somebody wouldn't get on the stand and testify, correct? Okay. So now let's talk a little bit about punishment. I don't want to beat a dead horse. I know we talked a lot about this with Mr. Sanders and the judge. Kind of explain this to you as well. So what I really want to get down to is this, right? Just like number 14 said, he feels that probation is too light, right? Am I correct in that?
Yeah.
Yeah.
But again, I think it depends on the crime.
Okay, and that's a great answer for you, right? But I really want to get into is who feels that they wouldn't even be able to consider probation at all if you were to find, don't raise your cards yet, just hear me out. But if you were to go and say, you know what, I'm one of the 12 jurors and I found Mr. Huerta guilty, that automatically means for me, jail time, right? I cannot consider probation whatsoever. Doesn't matter what the facts are, right? Doesn't matter what's going on behind the scenes. Doesn't matter what happened. With this type of charge being second-degree felony, it's very serious. He's going to jail, right? I cannot consider probation.
And everyone, just a moment. It is not whether or not you can consider probation for the person who's here today. It's just in general.
Yeah. In general, I apologize. So in general, for this type of offense, right? Who would not feel that they could consider probation? Please raise your cards up. 64, 34, 31, 49, and 75. Not even if it was Aaron Rodgers, sir? Well, maybe, right? Just messing. 45? Especially, yeah, right.
I feel the opposite. The system is so rigid.
Okay, I appreciate you, sir. Yeah, I'm just trying to not go over my time here, so we're not going to get into all the numbers, but that's really the crux of what we're getting into there, what we want to know. And I appreciate you guys. So my next point, right? Basically, this whole process is to ensure that we give Mr. Huerta a fair trial, just like any of us would want for any of our fellow San Antonians, our Bexar County members. We would want everyone to have a fair trial. So what I really want to know is that at the end of the day, each one of you, from juror number 1 all the way to juror 75, would you be able to look at Roland and say, Roland, I will give you a fair trial? I'm not saying for you guys to blurt it out. What I really want to know, is there anybody here who feels they could not give him a fair trial for whatever reason? I'm not going to get into the facts of it, but if some of you feel that you've been affected by a family member or a friend who's been a victim of an assault, or you yourself, and you feel like this is not the trial for me, right now is the time. It's like we're getting married. Speak now or forever hold your peace, right? Can you raise your hands if you feel you could not give Mr. Huerta a fair trial? And I've got juror 9, 11, 12, 62, 64, 35, 34, 30, 37, 38, and 49. As Mr. Sanders told you when he was wrapping things up, is there anything else that we did not talk about that you feel? Yes, sir. What about? I was just gonna say, if there's anything else that you didn't get a chance to say, maybe you're feeling a little reserved when Mr. Sanders was talking with you, and now you might feel a little more comfortable, a little braver. Or if you feel like you want to come up afterwards, just raise your hand and say, I'd like to come up afterwards and not tell everybody in the panel, okay? Yes, sir, 64.
I just want to add, I'm also a former officer with the Texas Department of Justice.
Okay.
Just wanted to put that.
Appreciate it, sir. Thank you so much. Yes, sir. 45.
Just to say that I don't think it's a good deal, but on Friday, for the thinking of being prepared for years.
Okay.
And they come over here, so.
We'll discuss it. Okay, but we'll make note of it that you've got something coming up on Friday. 31? Absolutely. Yes, sir. I appreciate you for coming forward. And 38?
I see you out.
Yes, sir. Absolutely. 73? We'd like to see you after? Okay, thank you. Are we getting these numbers down? The people? Okay, raise your hand if you wanted to see us afterwards and speak in private. It won't be full private, right? State's got to hear, judge's got to hear, but at least the panel won't hear. So I've got 31, 11, 45, 49, and 73. Thank you guys so much for your honesty. I do have one further question. You just kind of triggered something in my mind here. Does anybody here have any family members or you yourself who in the past worked for the DA's office? 31. Do you mind kind of explaining that?
Well, my nephew was a bailiff.
A bailiff? Okay. Thank you, sir. Appreciate that. Anybody else? Oh, 69. Yes, sir.
I have a brother-in-law who was here at the pre-commission department. Yeah.
He worked with the district attorney's office? Okay. Thank you so much for your honesty, sir. I appreciate it. Thank you, guys. That's my time. And again, please don't think we're rude if we don't talk to you. That goes for the rest of the trial and for the 12 of you. We're not allowed to speak to you whatsoever. So if we see you in the hallway and we turn our head, it's not because we don't like you or something. We just want to make sure that all the rules are followed and that Mr. Huerta gets a fair trial. Okay. Thank you so much for your time.
All right, ladies and gentlemen, the jury, I'm going to ask that you step outside. We're going to come back at 12:30. So everyone who's in the jury box, if you'll make sure you take your belongings with you. And if everyone can take your belongings with you, but I need everyone lined up outside by 12:30. So everybody's rushing. Look to your left, look to your right. This is like paper chase. Remember the person, he knows paper chase. Okay, remember the person who's sitting next to you. So we all need to be back here at 12:30. Otherwise, nobody leaves. All right. All right, everyone, please rise for the jury. Number one, the state of defense may have some questions for you, defense, and if you could step back a little bit.
I
Thank you.
believe this is state's motion, Judge.
All right,
Yes,
state.
sir. So I have a few questions for you.
Yes.
Earlier when we discussed the one witness rule, and how the state won't, it's possible that we could bring just one witness. If you believe that witness and you believe they prove all the elements to you beyond a reasonable doubt, that that's enough under the law. But I believe you had an answer that said that you don't believe that wouldn't be enough for you. Is that right?
So there was a bit of confusion, and I think there was some discourse going around talking about whether if that witness was the victim or if it was someone else.
Mhm.
My answer lies on just the victim versus if it was the victim that didn't testify, but another witness, as long as it's a an outside factor. was
Mr.
what
Salcedo,
involves.
under
Yes.
the one witness rule, if the state were to bring one witness, and you
Yes.
believe that witness, and that witness testimony proves every element beyond a reasonable doubt, would you ask for more? Or would you be able to base your decision upon a one witness that you believe they're telling the truth, and that
Yes.
witness proves all of this, the elements that the state is presenting?
Yes.
So you will be able to make a decision based upon that one witness.
Yes.
No matter who the witness is.
Yes.
Okay. And then also, when we were talking about having to prove the case to you beyond a reasonable doubt, I believe you said that you would require more than that.
I'm
Is that-
sorry, this is my first time here. So
Oh, no
like,
problem. I could have gotten it wrong.
yeah. So I think the way beyond a reasonable doubt, I think the confusion here stems from the fact that there is no definition.
Correct.
And so I guess making on one's judgment, I think for me, it's just hard to quantify what is the reasonable doubt necessarily. And I think that's where I don't know exactly where I stand on my definition of reasonable doubt. And that if there is an external factor that could still potentially linger over this case, that could be a factor. As unreasonable, I guess, as one may consider it. I know that's more of a kind of a fluid term, depends on the person you're asking. That's where I thought it was difficult to agree with that.
Okay. The last one was as far as the range of punishment and your ability to render a verdict based on the evidence that's presented.
Yes.
I believe you said that because he could potentially come to the jury for punishment and the range is 2 to 20, that would affect your ability to reach a verdict on guilt or innocence.
Yes.
Okay. And so even if we prove our case to you beyond a reasonable doubt, because of the possibility that you may have to make a decision on his punishment, you're saying you would be unable to find him guilty.
Yes.
Thank you.
May I ask a few questions, John? Yes, so in regards to the kind of that last answer there, not being able to, I guess, find him guilty, are you telling the court that because he may be punished, you wouldn't be able to decide whether he's innocent or guilty, or would you be able to follow the law and determine whether or not the state's met its burden? Could you repeat the question one more time? Yeah, I know there's a lot there. So basically what I want to break it down for is what Mr. Sanders is asking essentially of you, is saying, look, will you be able to find Mr. Huerta innocent or guilty? And so let me ask that. Would you be able to do that if you were picked as a juror, listen to the evidence that's presented to you? Would you be able to make a determination as to whether you thought he was innocent or guilty? In the context of aggravated assault with the punishable term of up to from 2 to 20 years, I don't believe I'd be able to make that decision properly. Okay. That I would be able to come to that conclusion. Okay. You mentioned that when you were leaving that you needed something that you wanted to say something, you had something come up? Yes, so this was an uncertainty, so I didn't mention anything, but I'm currently actively looking for employment, and I just got back from a long interview process. Okay. That was told of a date range that they're available so I can continue this interview process. And the dates that they had given me are basically 2 dates tomorrow and 2 times tomorrow and 2 times on Thursday. Okay. And so I have yet to respond back, letting them know of the possibility of being able to attend your. Yes. So I haven't responded back to that
All
email.
right, thank you. You can step outside.
Thank you.
Challenge for cause.
No objection.
One witness rule.
What was that? I'm sorry, I couldn't hear
It's
you.
the handbook, the one witness rule in this institution, for number 7.
I didn't think, oh, 7. Okay, yeah, I don't have that listed for number 7, but we're not in agreement with 7.
Carter, is that the only issue?
Yes, Judge.
Could you bring in juror number 7, please? And juror number 7, the state may have a question for you, state.
Yes, sir. I just wanted to go over something that we discussed earlier.
Sure.
When I talked about the one witness rule and I said that the law says that we can bring one witness, if that witness proves all the elements to you beyond a reasonable doubt, that's enough for a juror to find him guilty. And I believe you said that wouldn't be enough for you. Is that correct?
It does get tough. I mean, I think especially if the one witness is the victim, because then we get into the he said, she said. And so that's where, you know, I come from a Christian tradition, which has a biblical thing that says, you know, the old style was you had to have 2 witnesses for that reason. I think bottom line is if that testimony was so compelling that, yeah, I could do it. But my preponderance is that, boy, I'd really like to see more than just one witness to it, if that makes sense.
Okay, and so you said if it's, I guess, very compelling. So are you saying that it would need to be beyond a reasonable doubt in order for one witness to be enough?
It might, just because of that, you know, if you're staking, I mean, you brought up the point of you're talking about a person's freedom, that you really want to be sure you have that right.
All right, here's the question.
Sure, certainly. Sorry.
This is the question.
Yes.
If the state were to bring a witness, doesn't matter if it's the complainant, whoever it may be, and you hear the testimony from that one witness, because you know the burden stays with the state and it never goes to the defense. And you hear the testimony of that one witness, you believe that one witness. There's no issue for you with credibility.
Right.
And everything that they testified to you proves every element under the law that state must prove. And that's done beyond a reasonable doubt.
Mm-hmm.
Will you be able to base your decision of guilty or not guilty from that one witness?
I believe I could.
Will you? And see, here's the thing, these are all hypotheticals.
Exactly, and that's what makes it so
and this is
difficult,
the
because
thing.
I can think of 1,000 ifs.
Yeah, and see, this is the thing about the one witness rule. The key to the one witness rule is you believe the witness.
Right.
There's no reasonable doubt. You believe beyond a reasonable doubt that that witness, whomever that may be, that the state has called, that one witness, you believe what they're saying. So when people think of the one witness rule, they always think about, well, what about this? What about this? And the hypothetical that the state is giving you, the hypothetical is, there is no what about this or what about that, because this witness has testified, you believe everything that they say, or you believe some of what they say, but what they say that you believe, the state has proven their case beyond a reasonable doubt. So based upon that, will you be able to make a decision for guilty or not guilty? And I'm not speaking about Mr. Huerta. It's hypothetical. So that's the question.
And yes, I could.
Thank you.
All right, thank you.
All right, you're welcome.
Thank you.
Thank you.
Thank you.
All right, what is? Say, do you still wish to proceed? Sorry.
No, Judge.
All right, what's the issue with number 10?
One witness rule and requiring us to prove it beyond a reasonable doubt.
All right, could we bring in number 10, please? I have a question for you. And it's in regards to the one witness rule. Did you understand the one witness rule that was explained to you by the state?
Yeah, at first. Yeah.
So if the state were to bring one witness to you, just one, you believe what that witness is saying beyond a reasonable doubt, and what they're saying proves the state's case, will you be able to make a decision on guilt or not guilty? Will you be able to find someone guilty based upon one witness?
It depends on what kind of a case.
Well, let's say, here's the hypothetical. Let's pretend like it's an aggravated assault with a deadly weapon. Okay, that's the hypothetical. The state brings in one witness. You listen to that witness testify. You have no issues with whether or not that witness is telling the truth or not. You believe the witness is telling the truth. And that witness testifies to every element that the state needs to prove. Will you be able to find that person guilty based upon one witness?
Oh,
That's yes or no.
no.
Anything from the defense?
No, yeah.
All right, thank you.
All right.
Objections, Judge.
All right, then number, where is Robert? Or so, one of them. All right, number 2 will be challenge for cause is granted. All right, and then what is the issue with number 17?
Said that they were to require proof beyond a reasonable doubt.
All right, they also said they can't sit in judge. Defense, do you want to call that?
Yes, Judge.
All right, let's bring number 17. Change the call. That's okay. I hope you're not injured.
I do the
That's
same
gonna
thing.
leave a bruise. All right, number, juror, the state has a question for you.
Okay.
Yes, ma'am. Earlier when we were talking about the burden of proof and how it's on the state to prove beyond a reasonable doubt all the elements to you. What was your answer in regards to if you're able to find someone guilty based on beyond a reasonable doubt, or if you would need more than that, like if we would need to prove it to you beyond a shadow of a doubt or 100%?
Oh, I think I was kind of in between the numbers, but like, do you have the question, how it was presented?
I don't, but I guess just thinking about it now. So there's no legal definition for beyond a reasonable doubt. It's whatever it means to you. And so if we prove our case to you beyond a reasonable doubt, whatever that means to you, would that be enough? Or if you have a doubt, even if it's not reasonable, you have any type of doubt, you'd be like, they didn't prove the case.
I would kind of be iffy about it.
Okay, so I gotta lock you in one way or the other.
All right, Mr. Espinoza Vega. Hi. Yes. So the state has approved their case beyond a reasonable doubt. We don't have a legal definition for beyond a reasonable doubt. Beyond a reasonable doubt is whatever that means to you. Do you understand?
I think that's where I'm confused.
There's no definition. So the state can't give you a definition of beyond a reasonable doubt. I can't give you a definition. The defense can't give you a definition.
So I'm trying to see, or to tell you how I understand that however the case is presented, however y'all are taking the case, if there wasn't enough proof to believe, but that there could be something beyond, is that what that means? I don't know. I guess that's where I'm confused.
No, I understand. All right. Any other questions?
One other, I believe you also raised your hand when you said that you would be unable to reach a verdict based on your religious or moral beliefs.
Right.
Okay, you're unable to stand in judgment of another. Or what are your feelings on that? If you're chosen for the jury and you have to deliberate on this case, would you be?
Oh,
able
well,
to?
if it's in this case, I'd be okay. I guess I was thinking that as in general, in any case where if it's something like major verdict where I would be based on my religious beliefs is where I would be kind of like, no, I don't know, I'm not sure.
That's what.
All right, thank you so much.
Thank you.
So,
Judge, we still challenged for cause based on requiring us to prove it beyond a reasonable doubt.
We don't agree that she said that, Your
all
Honor.
right, that'll be denied. All right, what's the issue with number 18?
Same thing. Beyond a reasonable doubt.
Okay, who are the people who are beyond a reasonable doubt?
18, 32, and 71.
All right, can you bring in jurors 18, 32, and 71, please?
Sorry, Judge, and 45.
And 45. I'm sorry,
Give me 2 minutes. I'm sorry, was it 18?
18, 32, 45, and 71.
Altogether?
Yes, please. Put it in all together.
No, nothing. Judge.
18 also had a time constraint or something.
All right, you guys can start a little bit.
Definitely.
You guys can step back
Yeah.
just a little bit, just about,
Oh,
just a little
okay.
bit, yes, because there's another juror who's coming in as well.
Okay.
So what juror number are you?
45.
45, and your juror number?
18.
And you?
32.
All right. I think here comes 71. All right, jurors 18. Yes. Jurors 18, 32, 45, 71. There's just some clarification that's being requested. Do y'all all understand that there's no definition of proof beyond a reasonable doubt? Do all of you understand that there is no legal definition for proof beyond a reasonable doubt? Number 18, do you understand that?
Yes.
32, do you understand that?
Yes.
45, do you understand that?
Yes.
71, do you understand that there's no definition for proof beyond a reasonable doubt?
Yes.
Do you understand that proof beyond a reasonable doubt is whatever your determination of proof beyond a reasonable doubt? Do you all understand that?
Yes.
Yes.
Do you understand that the state has the burden of proof in this case?
Yes.
Yes.
Do you understand that they have to prove their case beyond a reasonable doubt?
Yes.
Yes.
All right, with that being said, I'm going to turn it over to the state.
And so with that, would you require us to prove our case to you beyond a reasonable doubt? As in, remember we don't have to prove it beyond a shadow of a doubt, 100%, just beyond a reasonable doubt. And if you have a doubt, it can't. If you have a doubt has to go to the elements. Remember, we talked about that. And so if you have a reasonable doubt about the elements, then we didn't prove our case. But if you have just a doubt, like with the dog example in food, that's not enough. And so my question is, will you require us to prove the elements to you beyond a reasonable doubt? Or is beyond a reasonable doubt enough for you? Juror number 18.
Beyond a reasonable doubt is enough.
Okay, 32
Yes.
is enough?
Yes.
45?
Counselor, and I'm sorry, ladies, further. So the issue that I have is because being naive, at least I have a PhD in engineering, and we're building on top of something that is not defined. There's no definition of reasonable doubt, and then you're saying, so we build this on top of it. In my area, you have an experiment, it matches 100% the probability of, so I'm having kind of like a blur in my mind following you with all this.
So juror number 45, I understand about the engineering and everything, but in the law, there's no definition for proof beyond a reasonable doubt.
Correct.
So if you believe that the state has proven their case beyond a reasonable doubt, is that enough for you? Or are you going to ask for more?
That is enough, yes. Yeah.
All right.
That
Juror
is
number
enough?
It is enough.
Okay.
Yes.
71, All right, any other questions from either side?
Just for 45, Judge.
All right, so juror number 18, 32, and 71. If you can go back outside, please. All right, question for number 45.
Yes, sir. Earlier, I discussed the one witness rule and how we have to prove the elements to beyond a reasonable doubt, and we can do that through just one witness. And if you believe every witness beyond a reasonable doubt that that's enough legally. I believe you said that you would need more than one witness. Is that correct?
Before understanding that the law says that you need that and that's all you need, then I can play by those.
Okay, so you can follow the law, and if one witness proves all the elements beyond a reasonable doubt, you'll find it. You can find someone to go.
Granted, it's my belief of not showing facts or anything else, it's just the witness. So, but I can follow that, I can follow you basically
Okay,
and gain my own decision.
okay, thank you.
Any questions?
No
All right,
questions.
thank you.
Sit back.
Yes.
Yes, sir.
One witness rule.
And of the list that you have with the remaining numbers, who is the one witness?
20, 24, 28, 29, 41, 42, 43, and 58.
All right, any objection to bringing all of those in at the same time?
No, Your Honor, can we just get a ruling on 18, 32, 45, and 71?
I would-
You withdrew it? Okay,
Yes.
I didn't hear that. I'm sorry, Your
No
Honor.
problem. All right, Deputy Laura, can you bring in number 20, 24, 28, 29, 41, 42, 43, and 58?
Get this correct. 20, 24, 28, 29, 41, 42, 43, and 58.
Yes.
I'm a big
Judge,
little
I thought we agreed on 29 already.
You guys definitely, Laura, knows we don't need 21.
Sorry.
Did we agree on
Yeah, we did.
All right, thank you. She said this is one witness.
28 also had to, couldn't sit in judgment.
All right, what is your number?
20.
All right. What is your number?
24?
All right, come on up.
Oh, sorry.
No problem. What is your number? Okay, come on down.
The price is right.
Yeah, I get it. All right, come down. What is your number?
21.
21,
41.
41, and who
Yes.
else?
42.
All right, and who else?
43.
43. And what is your number?
Should be 50.
58.
All right, everyone, there's one question for y'all. We may have another question, an additional question for someone else. So for now, here's the question. And it's about the one witness rule. Here's the key to the one witness rule. If the state calls one witness and you believe that witness, you believe their testimony, it's not where you're saying, well, I really don't believe them, I would need more information. It's you believe, in this hypothetical, there's one witness. That witness is called to testify. You believe they're telling the truth. And what they're saying proves every element of the state's case. Is everyone following the hypothetical? This is not about Mr. HUERTA. This is not about his case. This is just a general hypothetical. So the key to the one witness rule, when people give you that example, is that you believe the testimony of the one witness. And the testimony of that one witness goes to the every element that the state must prove in their case. Does everyone understand? That's the foundation. State?
And so if you believe that, and you believe that we proved it to you beyond a reasonable doubt, I had y'all marked down that some of y'all said that that wouldn't be enough, that you would still need more than one witness, even given all of that. And so I want to ask you again, is your answer that you would require more than one witness, even if you believe that witness proves all the elements to you beyond a reasonable doubt? And you were juror number 20? Yes, ma'am. So would you require more than one witness?
Yes.
Juror number,
24, sir.
your answer?
Yes, sir.
Juror number 28?
Yes.
Juror number
58.
58?
Yes.
Juror number
41.
41?
Yes.
42. 42? Okay, and your answer?
I did have a question on it. Would it still include the additional evidence or just solely the one witness?
Yeah, here's the complete hypothetical. There's one witness. When people start adding to the hypothetical and saying, I need this, I need that, that means that it could be possible that you don't believe everything that the witness is saying. So in the hypothetical that the state is giving you, there's no issue for you about the credibility of the witness as it relates to the elements that the state is trying to prove.
That's it.
No.
Change my mind.
Okay, so you would be able to find someone guilty based on one witness?
Yeah.
Okay, and juror number
43.
43?
And it's no also.
You would be unable to find someone guilty. Thank you.
Let's do this because it
Yeah.
seems like people are doing double negative. Okay, we're gonna go over it like this. Number 20, you've heard the explanation. Do you understand the hypothetical?
So you're saying that only the witness, that's all the state's gonna use?
No, this is a hypothetical. This is not about this case. In general, if you have one witness, and everybody listen to the hypothetical, there's one witness. That witness is credible to you. What they're testifying to is credible, and it approves every element that the state has to prove their case beyond a reasonable doubt. So there's no question for you about, did that witness prove that element? You're saying, yes, I believe what they're saying, they're credible, they proved it. So the question for you is that one witness, is that going to be enough for you to find someone guilty in that hypothetical? So what I want from each of you is, yes, it's enough to find them guilty, or either no, it's not enough for you. So juror number 20.
Yes.
24.
No, Your Honor.
28.
Yes.
21.
41?
I'm sorry, 41, yes.
No.
42.
Yes.
43.
Yes.
58.
Yes.
All right, have I missed anybody? Now with those answers, state defense, do you have any other questions?
I think from the defense.
Just for 28, Judge.
All right, then 20, 24, 41, 42, 43, and 58, you can go back outside.
Twenty-eight.
28. Who's 28?
Who's 28?
28.
All right, I need you to stay.
Thank you.
Since we're gonna have to run and track it there.
All right, the state has some questions for you.
Sure. I believe you also raised your hand. It was towards the end of my question when I was talking about law enforcement bias, or if you felt that you couldn't be fair and impartial. I asked a bunch of different questions, knew someone who's been arrested or convicted, things like that. Ultimately, my question is, do you think you could be fair and impartial and not be biased towards one side or the other in this case? Now, who would you be biased against?
I would lean more towards the defendant in a case, hypothetically, just because I've seen law enforcement take matters into the wrong hands multiple times. It's not that I don't believe in law enforcement, just more who, like, controls law enforcement, who implements what rules. I don't know, just, or it's kind of just, I guess, how law enforcement decides to deal with certain things at certain times.
Okay. So would you hold her to a higher burden in order to?
What do you mean by that? Sorry.
Would we have to do more to convince you, other than proving the case beyond a reasonable doubt?
I guess I would just have to change. That's about it. I mean, there's not anything that you can do because you're not law enforcement. Right? It just would have to be like overall same change within law enforcement.
Pastor or Judge?
Few questions.
Yes.
But I guess kind of what we're getting at, sir, is that would you be able to sit in that box and hear all of the testimony and give it its fair chance to convince you whether or not you believe it or not?
Yeah.
Okay, so based on your beliefs, you're not coming in here saying, you know what, I don't care what that officer, any law enforcement officer tells me, and you would give them a fair chance to be able to convince you. I have no other questions.
And would you base your decision solely on the evidence that's presented in the law, or would those other factors that are in your mind play a factor in your decision making?
I could only go by what I see. And what's like presented. So, yeah.
Thank you.
All right, thank you.
Thank you, sir.
So with regards to number 20,
Challenge for cause still, Judge.
We're not in agreement. I believe they said that they
all right, that'll be denied. Number 24,
Challenge for cause.
no objection on 24, Your Honor.
okay, 24, state's challenge for cause is granted. All right, 28,
Challenge for cause.
We're not in agreement with that, Your Honor. Thank
all
you.
right, state's challenge for cause on number 28 is granted. 41,
Challenge for cause.
No objection to 41, Your Honor.
all right, challenge for cause for number 41 will be granted. 42. State 42.
I remember who that was, Sergeant.
42 was Joshua Slayton.
We withdraw challenge.
All right, 43,
A challenge for cause.
I'm in agreement, Your Honor, with the legal witness said, or the juror, I'm sorry, said it was enough.
all right, that'll be denied. 58,
Challenge for cause.
Same response, Your Honor. I believe the juror once clarified said one witness was enough.
all right, that will be denied. All right, then the remaining number we have for the state is number 35. What is the issue with 35?
I think 35 we agreed to, Judge.
All right, that's correct.
Yes.
All right, defense, we have number 44.
If we want to do the same thing, Your Honor, I'm sorry, for the presumption of innocence, it would be 55, 44, 48, and 46.
All right, could I say jurors 44, 46, 48, and 55?
Together?
Yes. Any objection from the state of the defense with three and jurors number 44, 46, 48, and 55 in together?
Nothing from the defense, Your Honor.
Nothing from the state.
All right, jurors number 44, 46, 48, and 55. All right, so we may have a few questions for you. Does everyone here understand about the presumption of innocence?
Yes, ma'am.
Does everyone understand that anybody who's accused of a crime in the United States of America, in Texas, in Bexar County, you are presumed to be innocent?
Yes, ma'am. Yes.
And you are presumed to be innocent, and that presumption is enough for you to be found not guilty if the state doesn't prove its case beyond a reasonable doubt. Does everyone understand?
Yes.
So right now, with no evidence being presented, someone will be found not guilty because you haven't heard any evidence. Does everyone understand that?
Yes, ma'am. Yes.
All right, so defense?
Yes, so, hello. When we spoke a little bit, remember we talked about that presumption of innocence? That was the whole, going to Vegas and asking if you're cheating, any type of thing, right? There's no right or wrong answers, you're not in trouble. What we're trying to get to is the bottom of any sort of bias that you may have, right? It could be with the legal system, something that you've dealt with in the past. What we really want to get down to is how you feel basically being in this process of where we're at right now in a hypothetical sense, right? Not necessarily here, but like certainly like Mr. Huerta is right now, though. Being that we're here, remember we talked about 0, someone's completely innocent, or 10, it's very likely that they're guilty. So I want to make sure that we address that issue in regards to how you feel, right? Knowing though that the law is that they should be considered completely innocent. You guys answered in the affirmative, knowing that, hey, it's the way I feel. I'm already feeling like someone's a little bit guilty. So I want to make sure we go individually. You were juror number 48. So knowing the law and knowing what the judge just explained to you, would you be able to give Mr. Huerta or anybody in this position the presumption of innocence, or do you feel that he's somewhat guilty? It doesn't matter if you're 1 or 10.
Well, there's like a little part inside of me just that thinks he would be guilty, but I would still, if I was picked, I would still, like, I understand that he's innocent until proven guilty.
Okay. Understanding that though, and how you feel, I just want to make sure we're very clear, I guess. Is it your belief right now that he would be a little bit guilty?
Yes.
Okay. And same question for you.
No, so it has to be proven to me, like, not to me personally, but you know what I mean.
And what juror number were you on, sorry?
44.
44, okay.
And I'm 46.
Yes.
And I definitely feel like, we come here, you spend a lot of time and effort to, find jurors and, even though there is the law states that it's proof of innocence, I still have a feeling that, hey, there's got to be some sort of guilt.
Some sort of guilty, okay. And then your juror number 45?
55.
55, I'm sorry, okay. And what's your feeling on the same questions I just had for everybody?
I feel like if the state didn't prove it, it didn't happen.
Okay, appreciate your honesty. Thank you so much, sir. I have no further questions.
All right, any other questions, State?
Yes, Judge, for juror number
46, sir.
46 and 48.
All right, so just 1 moment. So there are no questions for 44 and 55?
No, Judge.
All right, jurors number 44 and 55, I'll wait outside first. Thank you. All right, juror number 46.
Yes, ma'am.
Yes, sir. And so you would agree, are you understood that the burden is on us to prove the case, correct?
Yes, sir.
And so even though you may feel or come in thinking, okay, maybe he did something or he still did something. If we don't put on evidence, we don't convince you beyond a reasonable doubt through evidence that he committed the offense, would you be able to find him not guilty?
I mean, I think so, sir, because I do have feelings, and that's what you asked, right? But I do understand that there is a law and a set standard for things that need to be defined. You know what I mean? So like I'm ex-military, I know we have these standards that you have to meet, and if you don't meet those standards, then you're a no-go. And I would assume that it's the same thing, right? So you have these standards to prove that he's guilty without a reasonable doubt, and even though I have this bias, in stating, I definitely think that I could find him guilty or not guilty, depending on whether there's a reasonable doubt to all your points. Right?
Okay.
All right, thank you. You can step outside.
Yes, ma'am. Thank you.
I'm sorry, I forgot already.
48.
48. Okay, same question. Understanding that the burden is on us to prove our case to you. Even coming in thinking, oh, he may be guilty or having a bias one way or the other, would you hold us to our burden and require that we prove all the elements to you beyond a reasonable doubt? Or even if you think, no, they didn't prove it, but like I came in thinking he was a little guilty, so I'm not gonna set that aside and I'm gonna find him guilty.
Well, if it can be proven that he is guilty, then yes, he is guilty. But if it can't be proven, then I would think that he would be innocent.
Thank you.
All right, any further questions for this?
Not from the defense.
All right, thank you. Keep it way outside,
Thank you.
please. All right. That's with regards to number 46.
Well, I'll take them in order. I believe it was 44 first, Your Honor. We withdraw on 44.
All right.
46 would move to strike for cause.
Was that the guy or the lady? I'm sorry.
No, 46 was just the person who just walked out.
Judge, we believe that she said that she could follow the law and hold us to our burden. And my response will be the same for the other one. It's not, everyone comes in with a bias, but the question is, can they follow the law and hold us to our burden? And they both said that they could.
All right, number 46.
In regards to 46, Your Honor, I think it's very clear. She wasn't rehabilitated when it came towards her bias and thinking that Mr. Huerta is certainly at this point in the stage somewhat guilty. The question that was asked of her is whether or not she can
I'm
follow.
sorry, is she 46?
She might be 48.
Yeah, she was 48, yeah.
I was like, that says John Campbell. All right, so she's number 48.
48, yes. So in regards to 48, Judge, I mean, I know she says she can follow the law when it comes to holding the state to beyond a reasonable doubt, but that doesn't go to whether or not she holds any bias. And I think it's very clear that she does that in thinking she cannot give Mr. Huerta the full benefit of the doubt of his presumption of innocence at this point in time.
All right, that'll be denied. All right, then who's your other person?
We would move for cause on number 46 as well, Your Honor.
All right, number 46, state.
Judge, same response. I believe his was even clearer than 48 in that he said that he could, even with the way that he felt, that he could set it aside and base a verdict on the evidence that's presented here in court.
Our response would be, he flat out said it in his response, Your Honor, even with my bias, I can do this, but he's flat out saying, I have a bias. I don't believe he's innocent at this point. So he's going to require a burden from us to show he's innocent.
All right, with regards to number 46, and this defense's strike for cause to be granted.
We withdraw on 55, Your Honor.
All right, then you have 49 and 65.
And those will both be for the issue regarding the right to remain silent.
Could you bring in number 49 and 65?
Judge, I think we can agree to those without.
All right, Deputy Laura. Yeah, could you let her know that's okay? She doesn't have to bring minutes in.
Do you want to bring in the people that want to talk?
So you will agree to 49
Yes, Judge.
and then 65.
Yes.
All right, so off the record for a moment, I have is number 1, states strike for cause was granted. Number 4 was agreed to. Number 5, we agreed to excuse him because he has a possible excuse. Number 10, state strike for cause was granted. 11, 12, and 13 were agreed to. Number 24 states cause was granted.
May I interrupt, Your Honor? I don't believe we agreed to 13.
I believe it was
14, 11, 12, and
14. Okay, sorry about that. This is why we do this off the record. So 14 was agreed to, that's right.
Yes, sir.
And then 24 and 28 was states for cause was granted. 29 was agreed to. 34, 35, 36, 37, 38 was agreed to. 41 states cause was granted.
What was that last number, Judge? 41?
Was granted, correct?
Yes.
Okay. Number 46, defense's strike for cause was granted. Number 49 was agreed to. Number 64 and 65 was agreed to. Does anyone have anything that I do not have?
20, Your Honor, I don't believe I heard you say 20.
Agreed to? No.
No, Judge, I believe that was the states, or 20 wasn't struck, I'm sorry.
No, they withdrew.
I'm sorry.
They had called 20 up, but they withdrew.
They withdrew them, okay.
And so is everyone correct on that? Is that
That's what I've got, Judge.
Yes, I'm sorry, 61 was struck?
No.
No. Okay. So we have 41, 46, 49, 65.
No, okay, the numbers that are gone. Number 1, 4, 5, 10, 11, 12, 14, 24, 28, 29, 34, 35, 36, 37, 38, 41, 46, 49, 64, and 65. Does everyone have that?
That's what I've.
All right, and let's put it on the record quickly. All right, so the jurors that have been struck for cause and those who have been agreed to or excused are the following. Number 1, the state's strike for cause was granted. Number 4 was agreed to by both parties. Number 5 was agreed to by both parties. Juror number 5 did not appear. Juror number 5 did have a hospital excuse. Number 10, state's strike for cause was granted. 11 was agreed to by both parties. 12 was agreed to by both parties. 14 was agreed to by both parties. 24, state's strike for cause was granted. 28, state's strike for cause was granted. Number 29 was agreed to. 34, 35, 36, 37, and 38 were agreed to. 41, state strike was for cause was agreed to. 46, defendant's strike for cause was granted. And I'm sorry, 41 strikes for cause was the state strike for cause. It wasn't agreed to, but that was the state strike for cause. 46, defense's strike for cause was granted. 49 was agreed to. 64 and 65 were agreed to. State, are those the numbers that you have as being agreed to or struck for cause?
Yes, Judge.
Defense, are those numbers you have as agreed to as far as being struck for cause, agreed to?
Yes, Your Honor.
All right, we can go off the record. Let me see where that puts us.
I think
And
that takes
everyone
us to
I choose
42. Your Honor.
I'm sorry?
I think that would take us to 40.
Oh, just 1 second, let me see. Okay, I have this that's going to 51. You're saying you're at 42?
I might have counted it wrong.
Yeah,
Okay. Do you have 51?
I had 50, but I could have counted wrong. But I know it's more than
Let's
42.
recount. You know, math used to be my
Math,
strong
that's
suit
right.
since being in the law.
1, 2.
Sorry, and so you had as, oh,
Yeah, I have us, the strike zone is 51.
51.
You
You do?
guys not have it to 51? Let's count again, and everyone count silently to yourself. You know what, you may be right
Yeah.
to 50 because I counted one that wasn't in there. You like it's to 50. So you have it to 50.
I'm getting to 51, Judge. I don't know where I'm.
Oh, you know what it is?
What am
This
I
is
doing?
it is. Do you know number 13?
13, Julian Garza.
Yeah, that should be. You know, that
can't hear
wasn't
whispers.
agreed to or anything.
Oh,
And so you
okay.
may be counting that because I
Yeah.
have to strike it out.
Okay. All right.
So we're to number 50, and then your strike zone is gonna be 51, 52, 53, and 54. So in that range, each of you is given one more strike. So we'll have 2 alternates.
Okay.
So 51, 52, 53, 54, you have 1 more strike each from that.
Your Honor, how do you want to handle the people that needed to tell us? Because some of them fall within our little strike zone here, like 31 for sure.
You have that list? Yeah, 31, 11, 45, 49, 73, and
Well, let
1.
me see who's gone.
11's gone.
Yeah, so where is it? 31, that's 11. 45 is 45 gone, 45 is still here. 73 doesn't matter. 1 is gone already. 31, 45, what number is that?
49.
And 49 is gone. So really, we just need to hear from 31 and 45. They were ones who.
All right, can you bring in number 31? All right, juror number 31, there was something you wanted to say?
Yes, ma'am. I have
Yes.
2 issues about being a juror. I wear hearing aids and I still confuse dialogue quite often. I just don't hear clearly. Number 2, since I went through radiation, I cannot control when I go to the restroom. I literally cannot stop the urge. So those are 2
All right, well,
problems I deal with daily.
okay, well, with regards to the hearing thing, I think
Forgive me.
with regards to the hearing, we can let everyone know to speak up and everyone will have microphones. With regards to the restroom issue, just raise your hand and let us know and we can excuse, it's fine. So don't be embarrassed to do that. What ends up happening is sometimes we go. But if you just raise your hand, even if you're on the jury panel, either the deputies will see your hand raised or either Brenna or either the state or the defense, and they'll let me know and we'll take a break. So don't worry about that, okay?
It's embarrassing because sometimes it's often. That's
Oh,
what I'm
don't-
trying to
Don't
share
be-
with you.
Here's the thing, don't be embarrassed by that. That's been happening to me a lot lately as well. Not for your reasons, but don't be embarrassed about that, okay?
Yes, ma'am.
Because a lot of people need break. And I tell you what, I think Brenna will appreciate you raising your hand so she can take a break from typing everything down. But thank you for letting us know.
Yes, ma'am.
All right, thank you.
sir.
And also, could we see number 45?
Mr. Brightler over there. Raise your hand.
Judge, I'm gonna write you something.
Okay, thanks. Oh, okay.
It's on this.
Oh, I feel you.
Sorry, I didn't even think to bring you back in, but.
All right, you had an
Your
issue
Honor?
that you wanted to speak? Is there anything else you needed to discuss with
Oh, I'm
us?
sorry, Your Honor, just to, again, I'm running on this. I'm currently going through an adoption thing. It's not really, doesn't fit me in any form. I'm trying to adopt through next door.
Oh, no, this won't affect your ability to adopt.
Okay, and the second thing, very embarrassing that this is priority. This is very important. Friday, I have people coming over to UTSA. Been trying to beg him for years to come from Los Alamos, New Mexico for funding our lab. If that's a.
I teach at UTSA.
Where? What department?
I'm in political science.
Wow.
Yes, I teach campaign and election law and also trial advocacy and appellate law.
You might know my wife, Courtney Berry. She's well, anyway. That's
Yes,
another
I
thing.
do. But that won't affect anything.
No,
Yes.
I teach at the engineering department. So like, anyway, so I just wanted to say that I've been trying to get them to visit us for years, and if the answer is no, just worth asking.
No, thank you so much for letting us know. Thank you.
Thank you, sir.
All right, so if you guys will do your strikes and everything, and we will come back. So how long do you guys think that's gonna take?
if we can get a restroom break, and then I probably need about 15 minutes after that.
All right,
Yeah,
okay, so we'll come back at 1:45. You know what, let me ask you this.
Yes, ma'am.
Do the jurors need a break from standing, this is for the deputies, do they need a break from standing in line?
I think they're ready to go. And that's the truth, they're like eager. They're gonna hang their-
Well,
They're
tell
really-
them-
'cause it's hot.
Well,
It's because it's hot, the hallway is.
so do
hot.
you guys think that we can, let me put us on mute. All right, ladies and gentlemen, thank you so much for your service and for coming down here. The names that I call are people who need to take a seat in the jury box. Sarah Dow. Sarah Dow.
That's me.
Thank you. Joseph Oakley. Haley Vitek. Julian Garza. Monica Rodriguez. Lori Rusnick. Karina Rivera. Elizabeth Del Bosque. I think this is Gloria. It's been cut off. Gloria Uranga Martinez. Dorinda Carroll. Michelle Galvan. Kudarat Bamidele. Catherine Armstrong. Paramujit. Kyer. I know I'm mispronouncing the last name. Yes. All right, so the jurors in the jury box should correspond with juror number 2, 3, 8, 13, 15, 21, 22, 23, 25, 26, 27, 33, 52, and 53. All right, so ladies and gentlemen, for the rest of you, there are decisions for you to make. Now, when I tell you this, don't rush, let it marinate, think about it. You can be released for the remainder of the day, or you can go back downstairs and you can say, I would like to be on another panel. Think about that. All right. So here's the other thing, the forms that you're given, because you do get paid for your jury service. I know it's not a lot, it's not considered a lot, but you can either do that and at some point in time, you're just going to be minding your own day and a check's going to come in the mail and it will be enough probably for lunch, maybe. Or what you can do is you can donate that and they give to different organizations downstairs. Sometimes it's with foster children and maybe give it with different organizations, but that's always a good place to donate it if you want to donate it. But you do have your juror's excuse. So knowing that this is a great jury system and this is a great judicial system here in the United States, how many of you would like to be placed on another panel? See, I can't ask you to raise your card, so I'm assuming that you want to be placed on another panel. All right, so you're all excused. Thanks for coming by. And remember, you can always stop by courts and see what's going on. So everyone over here in the box, I'm going to give you instructions now because if everyone could move out quietly, please. I'm going to give you all instructions now because I know some of you are desperate probably to have lunch, right? So, oh, please be seated, everyone. So these are the instructions. We're going to start tomorrow at 9 a.m. But here's the issue with us starting at 9. We can't start at 9 unless everyone is here. So if one person is late, then we can't start. We'll have to wait for that person. When you come downtown, you're not going to be meeting in this courtroom. Deputy Laura or Deputy Mejia is going to show you where you meet. You're going to be meeting in the jury room. You can bring water if you want to drink some water. You can bring that. Just make sure it's something that has a cap on it because as you can see, the carpet tends to get very dirty and it never fails. Something always spills. I have no control over the temperature in this courtroom. Sometimes it's freezing cold, sometimes it's very hot. So it's best that you bring layers. It's okay for you to bring layers. We will normally, unless we're doing jury selection, we always take a lunch break, and our lunch break is always at maybe 12:30. It depends on if there's a witness on the stand. I really don't like to cut that off in half, so sometimes we may go beyond that point. The other thing in this courtroom, I try to have us recess every day at 4:30. The reason why I do that is because I know heavy traffic starts at 5. Again, the only exception to that is usually if there's some deliberation or if we're in the middle of the witness and maybe we can finish up that witness. So other than that, we usually will adjourn by 4:30. The other thing, do not investigate or look into any of this case. I don't expect it to be online or anywhere, but sometimes people want to do their Jessica Fletcher. Don't do the Jessica Fletcher. Everything that you hear that you will need to deliberate on and consider will come from inside this courtroom, okay? Come from witnesses' testimony, it will come from whatever exhibits. Do not investigate or look into anything or look into any parties about these cases, about this case from anywhere. Does everyone understand?
Yes.
If something comes on the news, which I don't expect it will, but if it does, just turn it on something else. And as I always do my bewitch example, don't listen to Mrs. Kravitz over the fence telling you what they saw, what they heard. Don't do that, okay? Any questions? Yes.
During the process, are we able to take notes?
You can take notes, but I don't encourage that. The reason why I don't encourage that is because when you begin deliberation, you're not allowed to take your notes with you or discuss them. So it's sort of best just to be in the moment and listen. I always say it's sort of like these days when people go to a concert, instead of enjoying the concert, they're just filming it from their phones. It's like be in the moment. So it's best that you not, so that you can just focus on listening what people are saying and pay attention to everything else. Yes. Yes.
Okay. Do we get another paper to take to work to say that we're gonna stay here till whatever?
The deputy will give you the paperwork that you need. And here's the thing, when you take that paper to work, if they have some issue with it, the deputy is going to give you a number. They can just call the court and I will say they are here.
Okay.
So that's not going to be a problem.
And it is gonna go till Friday, or could it potentially go till next week?
I never like to put timelines,
Okay.
but I think this may end on Friday. Okay.
All right, no problem.
Or maybe sooner. We'll see. All right, back row.
I'm assuming that is my question because my job, I need to give them heads up.
Yes. Oh, no, we will make sure that they know.
So I just need to know what the time frame is.
Yes. So everyone, just to be on the safe side, tell them you will be out this week. And if it goes beyond that, you'll know that before Friday. Yes.
Ma'am, I don't really like the issue of no English. So.
All right, we'll discuss that tomorrow, okay? So come back tomorrow. And this is me, when someone says they have a language issue, don't we all just speak louder like that makes it better? So just come back tomorrow. Are you able to understand tomorrow?
Yes.
Oh, I don't think it's Spanish.
No, I speak Hindi.
Awesome. Last time we had an issue and it was the person spoke Arabic. And I had friends in law school from different regions. I had a friend who was Navajo. And so they were trying to speak me that language. They only gave me terms that I consider rude terms. Like in Arabic, all I know is yalla, which is like hurry up. I know hurry up probably in every language. All right, and then you had a question or no? Okay. Yes.
Okay, so, never mind, I guess not. I'm processing so much. I teach and I have to process that I have to make 3 days of sub plans. And then okay, never mind.
Trust me, I know. I teach too at UTSA, so I know. All right, is there anyone else? All right, then we will see you all back here tomorrow at 9 a.m. All right, everyone, please rise for the jury.
And follow me, please.
Oh, no,
Okay, thank you, ma'am.
All right, so everyone, please be seated. So we're going to take our recess. We're going to be back at 2:30. And we can stop watching. We can stop.
Oh, you want